I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Dear God, as a new month comes, I pray for newness, a fresh start, a new beginning, many opportunities. May my mind be renewed, my heart refreshed, and my spirit lifted. Amen.
Amen.
Roll call.
Ms. Lees.
Aye, or here, I'm sorry.
Mr. Bryant.
Here.
Mr. Beck.
Here.
I move approval of the agenda.
Second. Go ahead. Phil got it.
Discussion, roll call.
Mr. Bryant.
Aye.
Mr. Beck.
There's one thing, though. The only question would be if we would want to entertain moving Resolution G 2022-52 into after the public hearing, so that if there are folks here specific to that topic, they don't necessarily have to
I can do that.
stay longer. Just that one item. Okay. Other than that, aye.
So do you want me to modify the agenda? Can direct to do
Yep.
that? To move it up?
I think, unless, without objection, we'll just make that
Okay.
move it up, make that modification.
Okay.
All right. I move approval of the minutes, regular meeting minutes from April 5th, 2022, record commission meeting minutes from April 5th, 2022, special meeting minutes for April 2022.
Second.
Discussion, roll call.
Mr. Beck.
Aye.
Ms. Lees.
Aye.
Mr. Bryant.
Aye.
Fiscal officers report.
As of May 1st, our HRA account has $14,245.44 in it. The operating account has $8,475,582.99. Our meter investment account has $8,174,957.66. Some of our major fund balances: the general fund has $2,827,000, $2,827,157.57. The park levy has $707,511.01. The police fund has $1,101,238.80. The fire fund has $734,935.11. The safety services fund is at $3,367,428.38. We received word today that the records retention schedule that we submitted to the Historical Society and the Auditor's Office have been approved, allowing us to shred many old records. This is a culmination of several months of detailed inventory process of 30 to 60 years of records. So we'll be able to free up some storage space. That's it.
Okay, thank you. Anybody questions? All right, moving on. We don't have any presentations, so I move to open the public hearing. A public hearing for the board to review text amendments to Section 31 definition, Section 51 general provision, Section 94 transitional regulation, Section 104 and 105E residential district, Section 115F lighting district, Section 124G heavy industrial district, Section 134H riverfront district, Section 135 double D planned multiple family residential district, Section 13600 planned residential district, 137 double E planned residential district, Section 138 double F planned lighting industrial district, Section 139, double G, Planned Heavy Industrial District, Section 143.2, Shared Parking, Section 146, Outdoor Lighting, Section 171, Additional Use, Height and Area Regulation and Exceptions, Section 320.4, and Section 32.1.5, Variable Message Center Regulations of the Symmes Township zoning resolutions. Okay, so at this,
Second.
oh, sorry. At this point, when we open the meeting, if anybody has comments, we'd love to hear them. Please come up and make sure you state your name and your address. So who would like to go first?
Are you going to do any presentation by zoning?
Did you want to,
Yes.
should we do a presentation?
Yeah, we'll let Brian go first.
Okay, Brian, go ahead. Presentation.
All right. Good evening, Brian Snyder, Hamilton County Planning and Development. This is a text amendment. The text amendments in Ohio are required to go through the same process as any other zone change. So similar to the multifamily zone change and the car dealership zone change, this has to follow the exact same process. That includes public hearing or public meetings with the Hamilton County Regional Planning Commission, public hearing with the Symmes Township Zoning Commission, and then those recommendations are presented to you at this hearing, and the ultimate authority to decide to approve, modify, or deny the text amendments is yours. So we have the Regional Planning Commission staff prepared a staff report with recommendations related to the text amendments. Those were presented to the Regional Planning Commission at their March 3rd public meeting. The Regional Planning Commission agreed with the staff recommendations with no changes, so whenever it says staff recommended, the Regional Planning Commission supported that recommendation. And then at the Zoning Commission hearing, there were some other modifications made. Kim, I believe, has prepared a summary of all of those, the recommendations of staff and the recommendations of the Zoning Commission, along with the original text. So that's what I'm going to go through rather than going through the staff report, just so we can get to the actual issues without too much delay. So we'll start at the beginning. Section 31.3 would add short-term rentals to the list of definitions in the zoning code. The issue that staff had with the definition was simply with the time frame. The initiated text amendment would include a one-year time frame. So anything, it says that if you offer a dwelling unit or portion thereof for fee for a term of less than 1 year, you're a short-term rental operator. Staff was concerned that the typical time frame for renting a house or an apartment is 1 year. So we recommended changing that to 1 month. So if you're renting for a month or less, you're a short-term rental. Longer than that, you would be covered by whatever the regular rental regulations are. That seems to be the time frame that's agreed upon by most other communities who have adopted text amendments for short-term rental definitions. So staff recommended that. The Planning Commission supported that. The Zoning Commission did not. The Zoning Commission agreed with the text as initiated and wants to keep the time frame for 1 year. Section 51.5, general provisions. This is a proposed new section to be added, which would state that short-term rentals shall not be permitted in any residence district. Staff was concerned with that as well for a number of reasons. First of all, prohibiting them in all residential districts makes all the existing short-term rentals grandfathered. They would not have a public hearing, they would not be permitted, but they would not have to go away. They'd be able to continue operating where they are with no input from the residents until they decided to stop doing it. Staff's recommendation has been, since the beginning of the issue with short-term rentals, is to treat them similar to bed and breakfasts, in that they would have to go through conditional use. Not that they fit the definition of bed and breakfast. We've had a lot of discussion about that in the township lately. Simply adding a definition would clarify that problem. And secondly, having short-term rentals be a conditional use would allow for us to tell them that there is a way in a residential district for them to do it, and that involves a public hearing with the Board of Zoning Appeals. Even the existing ones would have to go through that. We could enforce that and require them to go through the public hearing process, where the neighbors could be heard and conditions could be placed by the Board of Zoning Appeals. So we're recommending, staff is recommending that that rather than prohibiting them, that section 51.5 not be added, and that short-term rentals be treated as conditional use with the criteria F, H, M, P2, S, and X. Those are the same criteria that apply to bed and breakfasts currently. They would be applicable to this type of use as well. The zoning commission and the planning commission both agreed with staff that they should be treated as conditional uses and not prohibited. So that's the recommendation that's before you. Section 1.
Can I clarify a question? Can you go back to the grandfathered situation?
So when you take a use that is currently operating in a district that is not currently prohibited and prohibit it, then all of such uses are grandfathered in that district. So it's similar to when you create a residence district and there's a business there like Silver Spring House. When zoning was adopted in Symmes Township, that was a non-conforming use. It was allowed to remain and operate in perpetuity because it was grandfathered as a use that existed prior to the regulations that prohibited it. So there are short-term rentals being operated in single-family districts now. If you pass a text amendment that prohibits them in single-family districts, all the existing ones are grandfathered.
How will you know if they're grandfathered or not if you don't even know they exist?
We would have to do an inventory. When you do create a new nonconformity, you give people the opportunity to come in and petition for a legal nonconforming use. They would have to come in and show that they were in existence through some kind of evidence on the date that those text amendments go into effect.
And by using it as conditional use, we then can regulate them or not regulate them, correct?
The difference is that they would be permitted and there is a path for permitting them, and it's actually the way that they've been administered in the township since the very beginning. We've told them all that they have to go through conditional use. There was an appeal that was made to the Board of Zoning Appeals, but that decision is not final because it was appealed to the Court of Common Pleas. So as it stands currently, all of them are required to go through conditional use based on the interpretation that was made before the BZA case. Now, we're not enforcing that because it's in court. Until that decision is done, we're not clear on how to go forward with that, but this also takes care of it. One way or another, you're going to do something with short-term rentals, I would assume, and this will guide us for how we administer short-term rentals in the future.
Is there any grandfathering if we went to conditional use?
No, there's not. And the reason is because you're not prohibiting them in that district. And as I said, we've been telling them all along that they're conditional uses. This would just be clarifying and adding a definition so that there is no ambiguity, but the short-term rental operators have been told, if they've asked, that they're required to go through a conditional use review since the beginning.
And have they all gone through a conditional?
None of them have.
None of them have.
One of them appealed the decision that they should be short-term rental, or that they should be subject to conditional use review. That went to the Board of Zoning Appeals. The Board of Zoning Appeals made a decision, and that decision has been appealed. So that case is still pending.
Okay.
So basically, that decision, in a nutshell, said you're operating a business in a residential district that is not allowed, and this is a hotel. Hotels can only operate in a hotel zone district.
That was the decision of the Board of Zoning Appeals. Yes,
Correct.
that was appealed to the
So
Court of
that's
Common
what's in the
Pleas.
common pleas.
Correct.
So if we did not go the conditional use route, and depending on the verdict from the common pleas court, let's say that the judge agrees with the township zoning, then would that essentially abolish the grandfathering? That'd be across the board.
I don't believe so, no, because that's an interpretation that was made, appealed, and is being appealed. So whatever comes out of court would be the official interpretation that the township would be required to administer, unless the text of the code changes after that decision, which is the proposal here. You're making a text amendment, and the text amendment, I believe, would supersede the ruling of the court on that particular case, because that's an appeal of an interpretation. The interpretation would no longer be valid because the text would have changed after that.
Do you have a comment on that, Jeff?
No, I completely agree with that statement.
Okay.
So with conditional use, we have more control.
That's up for you. That's up to you to decide. The Board of Zoning Appeals has control over whether or not they get approved or don't get approved and what conditions may be placed on them. And prohibiting them, at least you're not allowing any more than already exist currently. So that's something for you to decide. Okay, sorry. Go ahead.
Yeah.
Thank you.
All right. I think I was at area and requirement, the heightened area requirements, section 137.3. This section requires a 20-foot setback for parking. It's different than most of the other codes that I'm involved in or have reviewed. In that if you require a 20-foot parking setback, you usually require more landscaping. In this case, the zoning resolution currently requires 10 feet of streetscape landscaping along the street. So 10 feet back from the right-of-way, you have to have 10 feet of landscaping. The extra 10 feet that you get from the 20-foot parking setback, by requiring parking spaces to be setback 20 when you're only requiring a 10-foot streetscape, you just get 10 feet of grass. There are a number of parking lots that were approved prior to Symmes Township taking local control of zoning. A lot of them are 10 feet. And we see a lot of variance requests to this. We see a lot of people wanting to keep their old parking lot because it already has a 10-foot setback rather than tearing it up because they'd have to meet the 20-foot parking setback. So staff supported this change. The Planning Commission supported this change. We actually recommended adding it to all the other sections that require a 20-foot setback just to make it uniform so that in all the commercial districts and industrial districts, all parking spaces are required to be setback 10 instead of 20. The Zoning Commission also agreed with that and agreed to add it to the other sections. So everybody's recommending approval of that. There was a modification to the shared parking agreement that was aiming to allow specifically restaurants and churches and offices to share parking. There was a section that was proposed to be added. Staff felt it was simpler if a couple of words got added to the existing sentences to just remove redundant language. Again, staff recommended that. The Planning Commission and Zoning Commission agreed with that. Outdoor lighting was proposed to be changed from having a maximum pole height of 15 feet from grade to a maximum pole height of 24 feet above grade. 15 feet to me has always been small has always been short in all of the zoning codes that I administer and am familiar with. I've not seen another place regulated it to 15 feet. That's not to say that there aren't other places that do. I'm not familiar with the villages around here, but a lot of the poles are greater than 15 feet. They have been historically. They are in most developments around the county taller than 15 feet. We get a number of variance requests to this as well. What we also get is a lot of people who are trying to use the existing poles rather than because they want to keep the height. Since the whole pole height is grandfathered, they keep the old poles when they move in and modify a site. So rather than getting new lighting poles, you get the same lighting poles where people are, trying to keep a Band-Aid on it and replace fixtures rather than replacing the whole light pole. Staff supported the change to 24 feet. There are a number of other places, as is pointed out in this document, that have 24 feet or greater lighting poles, so staff supported that. The Regional Planning Commission supported that as well. The Zoning Commission did not support that, and they recommended that you leave it at 15 feet. The next section is 171, additional use, height, and area regulations. This clarifies something that was an interpretation. A previous zoning administrator, we pointed out, as staff pointed out, an omission in the code where there was no maximum setback, no maximum projection of terraces, uncovered porches, decks, and the like into required yards. It was stated that you could extend into the yard, but it didn't actually tell you how far. I believe the intent was to make it 10 feet, which is the same as the section that it was taken from in the county code, but there was no number granted. The previous interpretation granted 14 feet. How the previous zoning administrator came up with 14 feet, I'm not sure. I wasn't part of that discussion. It seems like a strange number. 10 feet is a more normal number. It's a typical type of extension. You don't typically have front porches that are greater than 10 feet sticking off the front of the house. So 10 feet has been used in the county for decades and seems to work. We don't get a lot of variances to that section at all. So we recommended that we supported that change wholeheartedly. The zoning commission and planning commission also agreed with that change as well. Variable message centers in the O district. There's a lot of text shown. I believe this is all being added. And I don't believe that variable message centers are currently allowed in the O and O district. So all of this text is proposed to be added to allow them. All of these things are the same sections that are in the E district where they're already allowed. It just basically limits the type of variable message center that you can have. So it's not no videos, no flashing, no animation. Typical standards for variable message center signs. And again, they're consistent with what's in the E district already. So staff supported adding these to the O. There was a text amendment that these signs are permitted in residential districts for uses that require conditional use. We already talked about that. The conditional use is required still for churches and institutional uses in residential districts, but they're not seeking a variance. They're allowed to have them. So in the residential districts, they're allowed. In the retail districts, they're allowed. Right now, they're not allowed in the O district, which seems strange. If you're already allowing them in the residential district, they should probably be allowed in the O, since they're already allowed in the E. Staff supported this change, suggested the addition of a number 7 to this list that was initiated, just to require an auto-dimming photo cell so that the lights get less bright when it gets dark outside or when it's raining. The Regional Planning Commission supported this change along with staff, obviously, but the Zoning Commission did not. They recommended that that no changes be made, that this not be included in the text amendments. Section 321.4-1, wall signs in the E and EE district. This change would have limited the number of wall signs to 1 per building. Staff pointed out a number of issues that we had with this. There are a number of businesses that have 2 signs. You have a number of businesses that, for instance, have a logo box and then the name next to it. That's 2 signs. Everybody that has individual pin-mounted channel letters, are those more than 1 sign? We'll get people coming in and trying to put all of the things that they want to put on their building onto 1 box and trying to connect them with the pieces. Sign companies are very good at finding loopholes and making this work. So what we're getting out of this is just gigantic signs, 1 big sign instead of 4 or 5 small ones like you have currently on the front of Kroger. So staff recommended against changing this, against adding this at all. And the Planning Commission and Zoning Commission agreed with that change. Section 321.5, variable message centers. These are the digital signs that are currently permitted in the retail district. Currently, they're limited to 25% of the sign area. This would raise it to 50%. We do see a lot of digital signs in retail districts. They're currently permitted. We get a lot of variances to that 25% also. And 50% of 50 square feet is only 25 square feet. Staff didn't have a problem with this at all. There was a proposal to limit it to a maximum of 75 square feet. Staff didn't support that, or the existing 35 square feet. 50% of the overall sign should cover it, rather than having also a maximum square footage. The maximum square footages don't actually work out to 50% of anything or 25% of anything. So I'm not sure where they came from. The 50% is good enough, I would think, to cover this. The Planning Commission and the Zoning Commission also agreed with this. They did propose adding a number 7, again, to be consistent with the O. The number 7 was the auto-dimming photo cell. That's currently not required in the E district. That would also be added per the recommendation of the Zoning Commission, staff, and the Planning Commission. And then finally, the detached garage, section 351. There was a proposal to limit the number of detached structures to 1 per property. Staff had a number of issues with this as well, including everybody that has a shed and a garage or a shed and a pool house. Those are 2 already. Those are all those would all be non-conforming uses. And everybody that wanted to add 1 would probably be coming in for a variance. They probably already have a shed or something else in their backyard. So staff recommended against that. The Planning Commission and Zoning Commission agreed and did not support that change. That is all that I have. Those are the text amendments that are being recommended. They are being recommended to you by the Zoning Commission for approval, by the Planning Commission for approval, and by staff for approval. Obviously, there are staff's and the Planning Commission's recommendations, the initial initiated language, and the Zoning Commission's recommendations. They're not all exactly in agreement, so If you have any questions, I'd be happy to try and answer them.
Ken, Bill, do you have any questions?
Are we going to take these one at a time?
I think we.
Some of them have conflicting recommendations.
Yeah, we
Between
can
what
take
the
them one
planning
at a
commission
time,
and
sure.
staff and what the zoning commission recommended, yes, they do.
Or do we want to hear
Yeah, we
from the
wanna hear from
residents
public
first?
Yeah.
Let's,
Yeah.
and then we'll go through them.
Yeah.
Okay, that's fine. All right.
Thank you.
Thanks, Brian. Good job.
Tim, you guys have anything to say? No. Okay, so now we're going to open it up for public comment. So please come up, make your comment, give your name and your address. Who wants to be first?
My name's Kerry Kane. I live at 10120 Meadow Knoll. I have a question regarding the conditional use approval process. If the short-term rental thing becomes a conditional use approval thing by the BZA group, and if the person appealing that decision doesn't like the decision, then they can appeal that in a court, I assume. And then if they don't like the decision of that court, can they appeal it somewhere else? And where does the appeal process end?
Yeah, I went
Yeah, so
to
in a nutshell, anything that the BZA does is considered a quasi-judicial decision, which means it can be appealed to Hamilton County Common Pleas Court. Anyone adversely affected by that decision can appeal it to the Hamilton County Court of Appeals, First District Court of Appeals. Generally, that's where it may stop, although there is the only place after that is the Ohio Supreme Court, but you do not have an appeal as of right to the Supreme Court. You have to ask the Supreme Court essentially for permission to appeal, and there are limited circumstances where they allow appeals. That's why I say most cases of that nature, and if they get appealed at all, then they end at the Court of Appeals level. But they could go to the Supreme Court if the Supreme Court felt that it was
And in your experience in
Justified.
dealing with multiple townships and such, how often does the Court of Appeals overturn a BZA
I-
decision?
I couldn't say. I mean, it's
Half the
it's-
time,
I mean,
none?
I'm not going to give you a number. I'm going to tell you it is based
Sometimes, never.
sometimes, and it's based strictly on the facts and circumstances of that particular case. So,
Okay.
but giving you odds or a percentage is just not. It's not something I can
We've
do.
had cases go both ways,
Yeah.
in all honesty,
Mhm.
but we can't tell you the percentage.
So, and in that case, then a prohibition of short-term rentals would be slamming a door on new ones coming into the area,
Yes,
as opposed to a BZA approval and a potential appeal process.
correct.
I have a question of our law director. In light of something having gone through our Board of Appeals and being turned down and being appealed to Court of Common Pleas, what's our best process at this point? Should we try and enact a short-term rental, or should we wait for a decision, or I guess I'm not sure which way to go.
Here's what I can tell you.
Okay.
What you have before you is legislation to make a text amendment.
Yes.
Well, numerous text amendments, but
Okay.
the one that we're talking about right now would provide some, I guess what I would say, some final clarity to how the zoning administration would deal with these particular uses. What's being appealed right now in court is an interpretation of our existing code.
Okay.
So I'm not going to tell you I can't tell you what to do, but I can tell you that by doing something, putting something in the code, you will, the hope is you'll take away any need to have any interpretation of what the code means, because the code will just be clear, and further interpretations won't be necessary.
Okay. So in your personal opinion? Does it weaken or strengthen our case,
Which
the change in text?
I think you need, I would not look at these things as one strengthening one case or the other. Right now, there's a case that's in court challenging the interpretation of what our zoning resolution says right now.
Okay.
What's before you is an amendment to that resolution, which could bring clarity to the question that got us in the interpretation case in the first place.
Okay.
So how do we go after the ones that are currently in use when they never applied for anything? I mean, how do we
Well,
enforce it?
I'm not sure I can answer that yet because it will depend completely on
this.
how you act on this tonight.
Okay,
Okay.
okay.
I can tell you this, if you, and you have lots of options, obviously, but if you take the option that prohibits this use, any ones that are existing will be grandfathered in, and there will be no enforcement action with those. But I will tell you, and I think you sort of asked this, and Mr. Snyder answered this, the burden is on them to show that they would be a legal non-conforming use. They would have to present something to us to show, yes, I was already operating this way before you prohibited it.
Okay, but
But
so
that's prohibiting, not,
I
That's-
guess
What's the word?
I'm struggling with it is they
Well-
they technically weren't supposed to be doing it anyway. So, right?
Well, there was well, again,
So how do we
the-
say, okay, you're grandfathered in when you technically weren't supposed to be doing it anyway?
well,
Do you know what I'm
because
saying?
I think I understand what you're saying, but I think the issue is that the position that you weren't supposed to be doing it anyway was based on an interpretation of the existing code. And really the initial interpretation was you can do it if you follow the appropriate steps to get a conditional use permit.
And they never did.
Well,
Well-
we sent violation notice to
Right.
the first one that we heard about, and we sent them a notice indicating that they were in violation of the code because they didn't get their conditional use approval. There's an administrative process available to them that they could go through to get that approved in that location at that place. The first one that we sent it to is the one that appealed and now is in court. We didn't send out any other notices to any of the other operators because we don't know what the court is going to say. We're not sure if we're wasting our time sending notices to everybody because the interpretation was drastically changed by the Board of Zoning Appeals, and then that decision is appealed to the Court of Common Pleas. So at this point, we're waiting for both this text amendment or the resolution of the court case to tell us how to proceed further in the future.
Right, and that was my question. I think I understand, but I just want to clarify. When you say that if we prohibit short-term rentals this evening, then I believe our last count is somewhere around half a dozen that are currently operating.
Okay.
Then they would be grandfathered, but my understanding is only until the judge makes a ruling, and
No.
that
No.
ruling could say
No.
you're allowed to
That-
continue,
if-
or you're
No.
you're
I-
not allowed
If
to
you,
continue.
whatever action you take with respect to this text amendment will essentially potentially moot the court action. Because that court action is only based on the interpretation of our code as it exists right now today. If you take action doing anything, if you prohibit it, if you treat it like a conditional use, then our interpretation that we had to do before, it doesn't matter anymore. That interpretation is not relevant anymore. So we will be able to look at existing ones as the new amended code will tell us to. And that might mean they're grandfathered in. It might mean they have to get a conditional use permit. It might mean something else if you go a completely different way.
So then how does our action this evening impact the current court case?
That's my point, is I don't want you to think about your action tonight about how it's going to impact that court case, because
Because that continues, right?
well,
You said it would moot it.
it
but-
might moot it.
The outcome of it, but it will continue.
That case will continue,
Right.
but as Mr. Snyder said before, that case is all about the interpretation of a code provision. If you enact a new code provision, that will supersede whatever our old interpretation was. That old interpretation won't really mean much anymore, because we'll now have a new code that we're all working under.
Okay, thank you.
All right.
And I would ask that you take some action tonight, because I don't want to wait until this thing goes through the Court of Appeals, because that could be months and months. And in the meantime, there could be 25 more open up in the Symmes Township somewhere while this current case is going through an appeal process.
Yes.
Okay, we hear you.
So, Mr. Kane,
Yes.
you are a very vested member of our community on this subject.
Yes, I am.
You've been to many of our meetings. We've received correspondence from you. In fact, I think, didn't you even go up to Columbus?
I did.
And testify. So, I would appreciate your opinion to kind of help guide us through this on the subject of conditional use. Because it's my understanding that if we take this as it's written, then if you want to, you can lease your personally owned dwelling, but that is to be for, well, the way it's written, 12 months or longer. Period. We can make that 6 months or longer. I mean, that's what this is all about.
Right.
That's one decision.
The conditional use, if we go that direction, and it goes through the BZA, then that permits essentially what we currently have today.
They don't have.
They don't have to, but they might.
They might.
It's out of our control.
Okay.
Right, it's out of your control, and it's also out of control of the BZA, because the BZA could be overridden by the Court of Appeals.
True.
So if we want to, I have mixed emotions on it, because in
Yeah, so
order
do I.
to eliminate my personal interest in the house next door to me, I would like to go through conditional use, then have them be denied conditional use. And then,
Well,
of course,
there's a chance of.
there's a chance that they
Right now.
could be approved, or they could be appealed. The appeals court could approve it, so, or they could be,
But it'd be on a one at a time basis
all right.
on each
So that's what you're wanting?
appeal.
Well,
Right, but
I
the
don't
end
know.
result would be what we have today. You rent it
The worst
24
case-
hours.
The worst case would be what we have today.
Yeah.
Right. That'd be, the township would be stuck with a half dozen
Or
short-term
more.
rentals or more, however many are
Sure.
out there right now.
Yeah, there's nothing stopping, I mean, this
If
is a
you do the-
national
If you do the
trend.
prohibit use,
This is a national
perspective.
trend. And
we're stuck with
corporations
what
are buying up
exists.
houses and renting them. They're, yeah, we've all read about it.
So you would like conditional use?
Well, I'd like that, because that gives more local control, but the local control is kind of given up when it goes down to Hamilton County, because then I don't know what those folks are going to do,
Or goes to the state.
Make sure you.
or goes to the state. So
See, what do you mean by local control?
Symmes Township,
It has
local
to-
Yeah.
control.
Conditional use has to be granted by Symmes Township.
Right.
By
Board of
Symmes,
Appeals.
it's people within the township that have a vested interest in the township,
Correct.
that are working with the BZA or the zoning and the township trustees. Once it goes outside of Symmes Township, then you don't know who's going to be making that decision and what their motivations might be.
Okay, so help me. I'm confused. So we have a situation that we're not happy with, but we're saying if we go conditional use, then it's okay, because this entity has said it's all right. because
Well-
nothing else has changed.
Well, I think referring to what Brian has said before is the people, at least the first people next door to you, were told that it required conditional use, and they never went through the process, so they're trying to avoid the process.
Well,
So
they
what
had,
happens if we had conditional use on the books?
if this was passed the way it's recommended by staff, when we told them it was a conditional use, they would have had no standing to appeal that, because that wouldn't have been an interpretation. Their only option would have been to go through conditional use approval, and then if they didn't like that, to appeal that decision,
Correct.
like you're saying. The only reason that they had an option was because the text was not clear. There was an interpretation that was required, which is perfectly legally the responsibility of the township zoning administrator to make interpretations when the code isn't clear on a certain subject, which she did, and that's what was appealed. Like your law director said, if there was no need for an interpretation, there would be no appeal, there would be no case other than them applying to the Board of Zoning Appeals. So and since we're talking about this issue, I just noticed something that the Zoning Commission actually did recommend in this, and it's a minor change. If the section 31.3, if you have that, if they added single family, the word single family to a single family dwelling unit instead of a dwelling unit to remove apartments from the consideration as short-term rentals. So that's a recommendation of the Zoning Commission. But I also just wanted to clarify, staff's recommendation was not based on any of the cases specific to any of the problems that have been had so far. Our recommendation to make them a conditional use is honestly because these uses are 90% of the time located in residential districts. That's where they operate, and renting a house from somebody, which I've done on numerous occasions, feels much more like going to a bed and breakfast than it does like checking into a hotel. And so staff felt that they were more appropriate to be permitted and regulated in residential districts than prohibited in residential districts. We didn't make our recommendation based on, we felt like it was the lesser of two evils as it comes to the particular cases of the specific ones that are in existence. That's not why we recommended what we did. I just wanted to make that clear.
So if we put conditional use, if we make them go through the conditional use process, I mean, we technically could say you cannot rent it for one day. Could we do that?
The Board of Zoning Appeals would have the ability to place conditions on them that include something like that. I mean, I'm not sure, I haven't looked into case history of BZA approvals for short-term rentals, which I would have to do if that's the way it was going to go before the Board of Zoning Appeals meeting on the first case where it came before them. But they have the ability to place conditions, and as long as they're not illegal conditions, they can be enforced, they're enforceable, then they have the ability to do that.
So they would have the ability to say you can't rent it for one day. You could.
I believe so, but I'm not sure.
Or
I would
three,
have to-
or 3 days, or 5 days.
Define short-term rental here in
I mean,
31.3.
what I would say is exactly what Brian just said. In considering a conditional use permit request, they can impose reasonable legal conditions on that. I'm not going to sit here and tell you that a condition that says you can't rent it for one day would pass that test. I don't know, because we haven't done that kind of case law research to see. But in general, what I would tell you is they are permitted to place reasonable, legal, as long as it's not arbitrary, capricious, it needs to be related to what it is that you're regulating. But I can't, we just haven't gotten into what specific conditions might be or might not pass that test.
So, Mr. Beck, to answer your question, in that case, then I would be in favor of the prohibition, because that slams the door on new ones coming in.
Mm-hmm.
Because the thing that makes me wake up in the middle of the night is being surrounded by short-term rentals, because it definitely changes the character of the neighborhood.
Yes. Okay, I appreciate that. Thank you.
Thank you.
Yeah, sure, come on up.
Jay Batchelor. I live on 10119 Colborne Court. I live right behind Kerry, and the property that he was referencing on Meadowview is, half of it is in my backyard. So I'm a residence behind this problem house. And sorry, I've been out of town for many months, so I haven't been directly involved with the process, but Kerry's been keeping me up to date. So I understand the first proposal is if you prohibit, you grandfather, if you have provisional use, it doesn't. That seems like a better way to go, because we could actually prohibit or remove this house from the problem house behind us and next to Kerry. However, in the discussion here, I'm curious as to whether the zoning board and others have discussed what those provisions would be, what those conditions would be. So we've discussed 1 day, but my concern is that they vary from property to property, and over time there's inconsistency, and actually what we're trying to avoid, we end up having these multiple conditional uses and allowing these properties to continue to do what they're doing within certain provisions. So my recommendation, I don't know that I have a good recommendation. However, I might go the provisional way if you set a set of standard criteria in which you're going to evaluate each property against and hold some consistency to these properties, so that you are not dealing with a bunch of people coming in and saying, well, they got away with this, and why can't I have that same thing? So without some defined conditions that you preset, I foresee lots of problems with the second alternative. So I guess I'd rather have, like Kerry said, I'd rather have not a bunch of these, because there are a number of houses going up for sale in our neighborhood, and we anticipate that investors will be there and they'll end up doing the same thing as what's happening in our this house next to us. So I guess I'd rather avoid having more problem houses that are under certain conditions that are being met. But I think at minimum, if you go that route, you need to establish some clear, consistent provisions that these houses need to meet.
Brian, can we do that?
We put like a minimum 1 month limitation on it.
There are criteria that are being recommended that are in the conditional use chapter. They require no parking in the front yard setback area, that any parking areas be compatible with the neighborhood, that no exterior alterations or changes are made to the structure, that no signs be permitted, that exterior lighting be directed away from the residential properties, and there's one related to meals that actually doesn't apply. Okay. Well, meals should be served only to guests or residents of the facility, not to the general public. So,
okay, what about single family?
Those are the criteria, the conditional use criteria that are being recommended to be required as the base consideration by the Board of Zoning Appeals.
Proof of insurance for rental property. Can we impose that kind of thing on it?
I'm not sure.
Can we impose in the conditional use it has to be a minimum of 6 months?
Or 1 month or whatever.
1 month.
Well, we're trying here on a different one to set short-term rental
Well,
definition.
under conditional use,
Oh, under
so we
conditional
can
use.
get rid of
Yeah.
everything.
Well, let me let me jump in. I know we're focused on the prohibition versus conditional use, but
Yeah.
that all presupposes that you first you have to come up with the definition of short-term rental, and that's all. And that's another section where we already have there are differing recommendations there. So that once you decide what the definition of a short-term rental is, that might help decide whether it even has to get a conditional use permit or not.
But I guess the open question is, can we put a restriction on a conditional use for a time limitation?
All I can tell you is I'm not sure that I've ever seen that in any other conditional use.
That doesn't mean that it can't happen.
I'm not saying it can't happen. I'm just,
That just gives more grounds for appeal.
I mean, you're just, right. I mean, the truth is you're asking some very specific questions that I don't know that we can give you a good legal answer,
So,
because these are relatively newly regulated all around us. So there aren't a lot of great examples of what has passed tests and what hasn't passed a test. I mean, I will just go back to, generally speaking, the conditions that are imposed for a conditional use permit have to be reasonable, they have to be legal, they have to be related to the purpose of why it's a conditional use in the first place.
and what you get with most conditional uses, you have a base set of standards that are in the code that are the conditions that are first considered. So these are the things that we can say that we want you to do. But the point of having a public hearing with the Board of Zoning Appeals, rather than just allowing you to meet those conditions and get a permit, the reason that you have a public hearing is that the Board of Zoning Appeals is allowed to consider more than just the conditions that are in the code. They're allowed to consider the cases on a case-by-case basis, which is why leaving it vague is generally viewed as being better. That's why all of the conditional use chapters and all the zoning codes generally don't try and anticipate every possible scenario and put a regulation in for them. For instance, that you're concerned, not to single you out, but you live right behind a conditional use that bothers you. If it's going through the conditional use review and the Board of Zoning Appeals wants to require a 6-foot privacy fence and 10 pine trees be planted along your property line to offset the impact that is being made by the conditional use, they can do that. In another case, what's behind them might be a car lot or some retail use where a privacy fence and landscaping wouldn't make sense. So that's what the Board of Zoning Appeals does in every case that they have, not just for conditional uses, variances as well. They consider the neighbors, the impact on the neighborhood, the possibilities that they can place conditions that will address the concerns, and then they have the authority to do that. So that's what our recommendation is to have that public hearing process. If the board feels like they want to approve it, they can approve it with conditions, and they can address things like views and noise, outdoor music after hours, things that are typical to other zoning decisions. They have the authority to make those conditions and make those requirements.
Or they can deny it.
Or they can deny it, correct. That's right.
But I still think you need to have, you can't anticipate all the specifics, as you mentioned, that are going to occur on an individual property. But I think having some general criteria for which you're telling these potential renters or investors that they need to abide by would be something that they need to make sure that they're addressing up front. And, our major concern is our safety and safety of our neighbors and the safety of our kids. So having people show up in my backyard that have big bonfires going, or a big party going, or they're smoking dope out back, or they're, drinking beer and all that stuff, and my kids and my grandkids are around, that's not acceptable to me. And the foul language at 5:30 in the morning that the whole neighborhood can hear. So I think having some criteria for which you're evaluating these people against, whether you're going to grant or not grant this thing, is a reasonable thing. And having some safety considerations. I mean, background checks. I don't know whether they're doing background checks or not. Got a bunch of kids in the neighborhood. I don't know if there's a pedophile renting there or,
Right.
some
No,
guy from
that's a
prison,
very-
just busted out of prison
Yep.
is renting there, or whoever it is. So
Right.
I think you just need to have some base level criteria for evaluation. and then have the hearing and allow people to come and voice specific concerns that they might have for a specific property where these criteria may or may not apply. I mean, I'm not saying that you need to have everything spelled out from the get-go, but at least have something to start with that, gives us some assurance that, we're not going to have, compromised safety in our neighborhood.
If we would put a short-term rental and define it as a year, the ones that are active now, would they have to come back and go through conditional use?
Yes. I mean, you're defining that as less than a year. So yeah, all the ones that are renting it for a day, 10 days, 30 days, they all have to come back. They'd all be part of this 1 year time frame.
Okay, so if they come back and they're grandfathered in.
They're only grandfathered if you prohibit them.
So that's what I'm saying. If we're saying that if they have to be a year rental, they can't be a day rental.
Then they wouldn't be grandfathered. They would be permitted if they go through the process. The permissible.
So they would have to go through conditional use.
Correct.
Through the
The
BZA.
ones that are there.
Right.
And in conditional use, can they be denied
Yes.
if they go through conditional use?
Yes,
And
the board
we-
has the authority to deny the conditional use request, yes.
So that's probably the best route.
Well, the Board of Zoning Appeals absolutely has the right to deny a conditional use permit application. But I want to be clear that that is a quasi-judicial action that would be subject to an administrative appeal to Hamilton County Common Pleas Court.
Or they allow it and they put all these conditions on it, like you were talking about.
Yeah,
And that way you could stop, we have 6, or are we saying we think we have 6 so far?
Yes.
So we have 6, but we can put conditional use on those and we can stop the rest of them from coming in. Is that what I'm understanding?
The ones that, no, everybody would be able to come in and ask for a conditional use, yes. So, no, you wouldn't stop any future ones unless the Board of Zoning Appeals gets a reputation for denying them. That wouldn't prohibit them, no. You would be permitting them to go through conditional use approval.
But
They
if
could
you
go to the
put
board.
a year, if you put the minimum would be a year.
Well, this is just saying that it's basically, the definition that you've written basically says if you rent for longer than a year, you're not a short-term rental. You're just renting your house or your apartment like anybody else. If you're renting it for less than a year, you're a short-term rental. Like I said, if it's a day, 2 weeks, 3 months, 6 months, you're a short-term rental operator, and that's a short-term rental, and it's subject to conditional use. So you're not limiting it to a year, like they don't have to rent it for a year. That would be a regular lease agreement, like you have with anybody that's renting anything. That's, in fact, the typical lease term is 1 year. This is trying to clarify the difference. What is short-term? When does short-term stop being short-term and become long-term rentals? You're not trying to regulate long-term rentals. In fact, you're not allowed to. You're trying to regulate short-term rentals, and you're trying to define the term that defines short-term. This says 1 year. That's what's being recommended to you by the Zoning Commission.
Okay.
Thank you.
Okay, thank you.
Is there anyone else that wants to talk on this subject? Why we're here? Hello.
Hi, my name is Anna Lawson. I live at 11970 Streamside, so I'm in the same neighborhood. Want to thank you all for serving. You have difficult decisions to make, and it's complicated. So I'm just concerned, as a property owner, I'm just concerned about more regulations, more conditions on my rights as a property owner. I don't know what the future brings. I don't know if I'm going to need to go take care of my mother for a couple months and to offset expenses, rent out my house or something. You know, there's all sorts of issues or all sorts of things, so I don't envy you trying to figure out things you haven't even thought of yet. So I'm concerned about more regulations, and I'm wondering if there's other avenues. Do you currently have ordinances about noise, about partying,
Sure.
about bonfires in the backyard, that maybe just more education? I mean, I'm learning a lot tonight. Just more education on what homeowners can do when there's noise in your neighborhood, or my next door neighbor has parties, but it's better than where I used to live where there were 4 dogs. It's, I'm wondering if more education for us as residents would be useful, rather than more regulations and more conditions. But thank you.
Thank you.
Thank you.
My name is Kyle Watts, and I will live at 11993 Streamside. That's on the corner of Streamside and Bank Creek, next door to the short-term rental that's operating at 10007 Bank Creek. And I'm here today to say that it's become very real when this one started operating. This weekend, this past week, there's a new set of renters. They have loud music. Their house is closed. All the windows are closed. All of my windows are closed. I can still hear their music. This weekend, there's 4 cars that are there throughout this past week. Then this weekend, there was another car with some other people that didn't seem to belong there either. The music was very loud into the middle of the night. I have pictures on my phone of beer bottles out in the yard and on the driveway. When I confronted the person that happened to be sitting in their car, with which the beer bottle was sitting out there for a long time, I said, "What's going on? Can you at least clean up all the garbage that you're leaving out in the front of the yard? And can you turn down your music?" And his response was, "Oh, mucho drinking." And so we've been closing our blinds. Our kids are not allowed outside. My suggestion is we go through the conditional use, because I'm selfish. And if we prohibit it, then they're grandfathered, and I have no chance. Because I'm not confident in the decision of the Common Pleas Court.
Who's the judge? Do you know?
I do not know
Okay.
what judge it is.
And so I think the best solution for me, because I'm selfish, because I live in a corner, I realize the broader community might want to see just prohibiting it, and we'll deal with what we got, but I got to deal with what we got forever.
Mm-hmm.
And so I'd rather have it go through the conditional use process, where we can at least limit some of these things. From now on, I'm going to be calling the police every time this stuff happens.
Well,
Okay, so my opinion is create a process where things have to go through a review process. I'm actually not against short-term rentals. I think it should be allowed, actually. But it makes sense. If someone has a property on several acres of area, please, investors, buy that. It's a great thing. I believe in freedom to do that stuff. But what I don't believe in is short-term rentals, hotels, whatever you want to call it. It certainly feels like a hotel to me. The situation when the BZA came out, not what I was expecting. I was expecting to go through the conditional use process. So that was a surprise. But I just think, going back to what I'm recommending, going through the conditional use process, because it gives at least me some hope that perhaps something could be very much limited or even denied, because otherwise I'm stuck.
Right, right. And Mr. Watts, thank you also. You're a very vested member of the community on this subject. Yes.
Hi, my name is Linda Hall, 9857 Montgomery Road. I'm a realtor. I represent several buyers, some of which have bought short-term rentals in this community and others. So I have a vested interest. The residents mention safety, they mention bonfires, they mention drinking, they mention sex offenders. Are you going to start doing background checks on everybody that lives on your street? Why should rules apply differently to someone who's staying there for 3 weeks than someone who's lived there for 3 years? It's not any different. Everybody has that neighbor on their street that they don't like. So
Could I ask, I'm sorry to interrupt.
Sure.
But I just wanted to clarify with the sheriff, if I may, on that topic, because I'm curious also.
Absolutely.
It's my understanding that sex offenders, they're registered, and you can actually go to the website to see where they are in your neighborhood.
Yes,
But not on a
they're
temporary-
on our website,
But
So
not
that-
on the
a
Hamilton
temporary
County
basis.
Sheriff's.
Yeah.
I'm sorry?
Not on a temporary basis.
Yeah.
Okay.
Okay, I just want to bring your attention to House Bill 563, which is before the State House. I'm sure you're well aware.
Yes.
It states, restricts local governments from prohibiting short-term rental properties within their community. It also prohibits local governments from regulating short-term rental properties, specifically the number, duration, or frequency of rental periods. So,
But I think that bill's being worked on right now.
Yes.
absolutely, it's in
Right.
committee.
So it's, right,
Right,
it doesn't mean anything right now, because it's being worked on.
Right.
So that all could change.
right, it all could change. So, I just want to speak to the fact that it sounds to me like you're trying to apply regulations differently to someone who's staying somewhere short-term versus long-term. And I think you're treading dangerous ground when you do that, because the only time that my clients have had the police called is when African Americans were staying at their rentals. That's the only time. There was a Hispanic babysitter sitting in the driveway. The police were called because she was sitting in the driveway. That was the only time. I think that's kind of interesting, because if somebody bought that house and had a Hispanic babysitter sitting in the driveway, would they call the police? Would they go over there and hassle that person? So we're just talking about different standards. If I owned a house and I want to move out, like Anna Lawson mentioned, for a couple months, and I want to rent the house to my Uncle Harry, your regulations would unfairly prohibit me from doing that. And now you're stepping on my property rights. So just understand, these are thorny issues, but you're talking about putting regulations in place that have a much wider scope than the narrow scope in which you're trying to apply them. That's it.
Thank you.
Thank you.
Kerry Kane again on Meadowlawn Drive. I'm not sure what this lady was referencing. There was a Hispanic babysitter sitting in a driveway for 3 hours. I did not call the police. I called the property owner and said, this woman needs some help because she's trying to get her phone out of her house so she could go where she's supposed to do. The police were never called. And there was one morning in September where there were a large group of people. I'm not sure what nationality they were or what ethnic they were, because I did not confront them. But the language they were using certainly sounded like they may have been African American, but I did not call the police. I called the property owner because he got a problem. So I don't know what kind of issue you're trying to raise.
Why don't you call your neighbor because someone's sitting in the driveway for 3 hours?
This lady
Hey, you
was-
guys can't fight, you guys, no.
This
They're not gonna-
this woman needed help because she was
Yeah.
locked out of her house, and she came over and asked me if I could help her.
Okay.
Okay, you guys.
She approached
you
me.
guys. You can address us, but don't.
She
yeah,
approached
don't
she
engage.
approached me. She approached me for help.
Okay. We have
Excuse
one
me.
speaker.
That's enough, okay?
So I just want to get the facts straight, because these people have a habit of lying.
Yeah.
Because the people that own the house next door to me said at the BZA meeting that they rented a house a dozen or so times, and they rented it for weeks and months at a time, when in fact it had been rented 50 times, and the average length of stay from May through February was 3.5 days. So they do not tell the truth. So they misrepresent the facts.
Okay,
So we need to take that into consideration.
thank you.
Thank you.
Okay, just a quick question. Does the county, do you have a regulation that requires rental registration?
Yes,
No.
You do? Okay,
Hamilton County does. Yes,
Yeah.
it does.
okay.
Okay.
Mark LeGuillen, 9355 McKinney Road. I'm going to go to something a little bit later. You have initiated a text amendment Or a portion of the amendment I'm opposed to with the definition of the lighting and the variable signs and increasing the size. I've got no problem with the theory of that. The problem that I have is, from what I understand, it's still undefined as to how many lumens you can put out at night versus the day versus the whatever. I do not believe any of the trustees live in an area that would be affected by illuminated signs. I believe that if you actually drive around the township at night, you can see where some of this would be issues since it's undefined. I'm
Can you tell me
concerned-
where, Mark? Can you tell me where?
Specifically, no,
Yeah.
Jody.
Okay, I just wanted to.
But I drive through the
Yeah, so I
township and
could drive by, yeah.
I drive through the township and I notice it's like, oh, okay, so they can make it brighter, and then we're talking about having dimmers to where they have to go down at night, but there's no standard as to how much light output there can be. That's all. That's all.
That's a good
That's my
point.
that's my
That's a
only
point.
Yeah.
you know, and I don't have that issue.
This is across the board, no matter what sign we're talking about.
Absolutely.
Yeah.
I think that's reasonable, commercial, residential, whatever, but my concern is more in the residential areas where there are churches and where there are whatever, and they have those signs, and nothing against churches, by the way. I believe that if that part of the zoning text amendment passes, that once you allow this additional light, if it's undefined, and you pass legislation, you can't put Pandora's light back into the box.
Okay.
My concern.
Can we define the lighting?
The maximum illumination level at the property line is 0.5 from all sources, including signs.
So that's across the board.
Yes.
0.5
So there is a maximum.
0.5 foot candles at the property line.
foot candles.
So
Illumination.
you're saying that it is definitely defined and the text amendment would not change that definition?
No, that's in a different section of the code. It applies to all lights on all properties. Outdoor lighting.
So this would not apply, okay.
Okay.
The other thing is, and I've heard all these folks talk about short-term rentals. And the thought that I had is I really sympathize and empathize with their situation. It is seriously something you guys have got to fix, however you do that. I don't think it's an easy problem either, by the way. My concern about short-term rentals is, somebody said a year, I believe. Have you had the problem of the neighbor who's renting the property, they've been there 3 years, you still have the problem that most of these folks discuss? It doesn't matter whether it's a week or whether it's 2 years. That problem exists ongoingly. So I don't know that just maybe defining some of the time frame makes sense, but if somebody rents a property for a house for a year and they don't know how much longer they're going to be in town, from what, if I understood or misunderstood, they want to extend their rental 3 months, they wouldn't be allowed to, is
Yes,
that
they
correct?
would.
Yes, they
Yeah.
would,
Yes, they would.
because they've been there for a year.
Okay, so it's, if you rent a property for longer than a year, I didn't know that was well-defined. The other thing is, in closing, I believe the text amendments, some of them are necessary and so on. The only thing I want to say is, you should not implement any zone text changes that negatively affect residents or interfere with their property rights. There are a couple of them I read through, and it was discussed about the detached garage in the building. Well, the way it's written, they're going to be in violation. And I just think that in talking to a lot of people in the past, they moved to Symmes because there wasn't a lot of regulation or HOA type rules and that kind of thing. So I just want to say you guys should be very considerate to everything you consider in the amendments for all the residents. I mean,
Right.
and like I said, I empathize. These folks, you know, the one thing I'll throw out is they're already zoning for how long you can make noise, whether it's in the structure or out of the structure, if I'm not mistaken.
There's a noise.
There's not?
There's noise regulation.
Yes,
It
we
says
regulate.
between 11 and 6 in the morning or something like that.
Okay. Well, and I think some of that is potentially avoidable maybe with the property owners of these short-term rentals, and say, look, it's going to be your problem, but if the neighbors have a problem, that's what our sheriff's department is for.
Yes.
If somebody's out of control or, you know, being belligerent or whatever, I empathize with their problem, but
Call the police.
we already have things that they have some options to. And I'm sure the sheriff's department would be happy to swing by and say, hey, you know, even if it's even if it's early in the evening and they're already getting loud. If they know about it, cruiser guy goes by and says, nah, this is not good. So that's all I got.
Thank you.
Thanks, Mark.
My name is Carol Symmes. I live at 9972 Washington Street, Camp Dennison, Ohio. I wasn't here tonight to talk about the short-term things, but I have a question for Mr. Bryan. What would the specific criteria that you mentioned would be part of this?
The ones that I read,
I didn't catch them.
no parking in the required front yard.
What's the letters? Do you know the letters offhand?
Yeah, they're in the text amendment. They're in our staff report. Do you have the staff
No, I
report?
don't have a staff report.
It's F, H, M, P2, S, and X.
Is there any reason why L, U, Y, and Z is not being considered? L being measures shall be in place to minimize impacts such as noise. U is security measures. Y is intensity of use, and Z is emergency response plan. So when an applicant wants to come before BZA for conditional use, they submit their application and they have to address the specific criteria, right?
Typically, yes.
Typically. So if those 4 additional items were part of the specific criteria, they would have to address how they're going to manage noise and security measures and that kind of stuff on that property.
Yes. Those criteria were intended for, I believe, things that are more commercial and industrial.
Correct, but listening to these neighbors, I mean, having problems with noise and concerned about security and that kind of stuff, it just seems to me that those are 4 additional items would be. Plus, in general considerations, you have adverse effect.
Correct,
Is
yeah,
taken
covered
into
that.
consideration.
Yep.
So that's stuff that the BZA would take into consideration when either approving or denying.
The
an
4
application.
general criteria would apply, yes.
Correct. Is there any reason, when BZA does approve it, are they able to set a specific time limit that approval is for, say for a year, 6 months, whatever, where the applicant has to come back?
We typically try and talk them out of that, but I've seen it done.
And when an application is made to BZA, then all of the adjoining property owners are advised of that?
Everybody within 200 feet gets a
Correct.
notice.
Okay. Okay. So there might be some 4 additional items that this board might want to consider as putting into specific criteria. I went online and your notice of this hearing, which was posted on April 7th, the only thing that it has on there is your initial resolution that initiated the zone changes. There's nothing on there that shows what was recommended and denied by the zoning commission. Your current resolution that you have that you're talking about adopting tonight was not online. So there's no way of knowing how you're going to take action on certain items, such as where the height of your poles, your zoning commission has said leave it 15. My question to you is, in this resolution that you're adopting tonight, are you leaving it at 15 or are you approving it at 24?
That's something we're going to discuss after the public hearing.
So you have a resolution that you've got that you're going to adopt tonight. So is it already set language, or are you going to take each item and then rewrite your resolution that you already have ready for adoption?
Yeah, I think we need to discuss each item and then
Rewrite.
how we vote is how that the resolution will reflect
Okay,
that.
okay. So just remember that your zoning commission has recommended that you leave light poles to 15 feet. There is a concern about light pollution. The fact that this should be changed simply because there's been variance granted is no reason to change the zoning code, which has been in place for this since 1996. Developers coming into our community should be aware of our zoning code, and they should know that our height of our poles are 15 feet, not 24.
I have a quick question. Brian, have you ever denied anybody?
Once or twice, I think.
How long ago?
I don't recall. Rare. It's rare.
Okay.
Yeah, the zoning commission sort of indicated when I talked to them at their public hearing is that they have been approving variances for the height of poles.
Yes, 24.
And you shouldn't be approving variances just because the developer wants it. There should be some kind of reason.
Well,
What's the reason?
I think what we're thinking right now, Carol, is that we go off to Board of Zoning Appeals and they approve these, and there's precedent set, and we keep sending people over there and they get passed anyway.
Most cases with your light poles are going to be in a commercial development, which is probably going to be covered by a final development plan, which will go before your zoning commission. So your zoning commission needs to understand that there is a zoning code in place. And it's like with BZA. BZA cannot grant a variance unless there's some kind of hardship.
Yes.
So
Well-
zoning commission should not be granting a variance.
Well, we don't control what they.
I know you don't control, but they evidently have said that they want light poles to be at 15 feet. So anytime now that they consider a variance concerning a light pole, I certainly
I
hope
have a
they'll
list of
consider
the
it leaving it at
exceptions.
15 feet.
I have a list of the exceptions, and it looks to
Okay.
me that you are indeed correct,
Okay.
that they are in a commercial area at 24.
So the other thing that they recommended not to be considered is your limit of accessory structures. Even your staff, Hamilton County has even said this should not be considered.
I'm sorry, Carol, could you
That's
repeat
the-
that? I
the-
missed.
Your limit of accessory structures.
351.
Oh, yeah, yeah.
Yeah,
Yeah, we got it.
351.4.
Detached, yes.
It's coming clearly from you, from Hamilton County, and from your zoning commission, but you need to delete that from consideration. You also need to delete from consideration 321.4, which is your double E signage. And as Brian said, that if you do that, there's going to be lots of grandfathering, correct? This is your Kroger signage and all that kind of stuff.
Oh, the limitation of one sign per business, yes.
Yeah.
We recommended against
It's
that.
going to be a nightmare with your grandfather stuff. What I'm mainly concerned about is your variable message signs in your O district. Hamilton County has said that they support it because not only is it now is allowed in your e-retail districts, but it's also allowed in your residential as a conditional use. And as I pointed out before, this was caused by a change to the text amendment previously that allowed these variable message signs in residential districts as a conditional use for churches, government entities, schools, so forth and so on. So saying that simply because now that everything is, variable message signs are allowed in e-retail, and they're also allowed in residential areas as conditional use, we should now allow them in your O and O districts. That's not, to me, is not a good reasoning to extend variable message signs into Symmes Township. Again, light pollution. I mean, do you know how many O districts and O businesses are located in your O districts? That you're opening this up now for a large number of variable message signs? Your zoning commission has said delete it from consideration. They don't agree with it. My concern is that it just seems that this request that you initiated was all because of a request from Union Savings Bank, and that you're trying to allow somehow for them to replace their existing sign, which they can't repair because there's no replacement parts. And they want to replace it with a variable message sign, but they're in an O district, they're not permitted. And it just seems to me that you're trying to change your zoning code strictly because of requests made by Union Savings Bank. I hope I'm wrong,
That is a building sign. This wouldn't permit that sign. They're still asking for a variance. FDP.
They're not asking for it, they're coming before,
Commission for a final development plan modification next month, correct?
exactly. And the reason is that they have to replace a sign regarding replacement existing sign as indicated in their application. And it strikes me really funny that they're saying they want to, where's the case at? Yeah, this is going to be heard on May 18th. They need to, the current wall sign is 24 inches by 14 feet 6 inches. And they need to replace it because they can't get replacement parts available. And they're so happy because it's now going to be a smaller sign. It's going to be 24 inches, 13 feet 1 inches. So, you know, it's great for them to come before your zoning commission for a modification. But you should not be changing the codes where they automatically are entitled to that variable message sign, ground-mounted variable message sign. Because by changing the code, not only are you then allowing Union Savings Bank to have it, you're allowing every business within an O district to have a variable message sign. It's bad enough that you're going down the highway and you're seeing all these variable message signs in our retail. And now the possibility, in Camp Dennison, because of conditional use, we could have 6 variable message signs in that small area of Camp Dennison because our 2 churches and our 4 parks that are down there. So all I'm saying is, please follow your recommendations of your zoning commission. Do not permit variable message signs in your O district. Thank you.
Thank you.
Good evening, Mark Hutton at 11621 Symmes Creek Drive. I have a little bit different perspective on the short-term rental situation. I use short-term rentals. Probably most of y'all have used them. Most of the people here probably have used them. And Mr. Snyder had said so himself. I often use that as a time to maybe get to know an area. So, you know, here in Symmes, right up the street, we've got P&G. We've got, you know, lots of people that maybe they're in for an executive, you know, some executive is in town for some short period of time, maybe 2 or 3 month assignment or something like that. Maybe P&G is going to put them up in a hotel. Maybe they're going to, you know, find a nice home. But I know when I used to travel a lot, I would have loved to have had the opportunity to stay in a home, stay in a house. And yes, I absolutely understand these folks have had some issues, and I certainly wouldn't want that, those kind of situations in my backyard. But as has been said, there's rules and regulations for noise ordinances and public alcohol and things like that would take care of that should address a lot of those issues. You know, my concern is certainly I'm you know, opposed to additional regulations and things on my private property and other properties, but you might also be limiting the people that have exposure, even in short term, to Symmes Township. Someone say, wow, this is a really great place. I stayed at this Airbnb for a couple of months while I was on assignment, or my family stayed while I was getting chemo in the hospital, or whatever. So there's other reasons, not just to come and party. And yeah, I'm not saying it doesn't happen. Obviously it has. And there's should be other regulations and things to try to regulate that. But you know, I could certainly have a Super Bowl party at my own house and get a little rowdy one night, but you know, that doesn't happen all the time. I don't think it happens all the time at these Airbnbs as well, or the short-term rentals. So I think the board should consider, you know, limiting it is limiting other kinds of things that might even be, you know, welcome to bring more people into town. That's my thoughts.
Thank you.
Hi, my name is Iwe, and I am neighbor to Carrie Kane at 10112 Meadow Knoll Drive. So I would like to speak directly on some of the topics that have been brought up because I'm a direct person. I would like to the issues that are here. So I think short-term rentals is a residential purpose regardless of the length of time. Like people have brought up, when people go to a place to stay, they're there for residential reasons. They're staying, they're cooking, they're there with their family. They are not doing any other activity that would make it anything else. Like they're not opening a hair salon, they're not doing, accounting. Like they're there to live there. And I don't think the length of time should determine, should have different regulations based on how long somebody is staying. And I feel like by introducing legislation and ordinance with the zoning ordinance and passing it, it seems like the personal preferences of the few is taken above the public good or what the public might need in this township. Because I know that it might not affect you, you might not care, but there are people who come and they want a place to live for their family while their child is getting chemo or needs to go to the hospital. Like the whole family, I had just quit their job from New York and they moved here so that their daughter can stay and go to UC. They could be closer, but they want to be in a neighborhood where their grandparents are here taking care of their other kids while the parents is with the daughter. They don't know how long they're going to stay, so they might stay for 2 weeks and then extend as long as is needed for their medical treatments. Like you may not have kids like that, or you might not have families visiting. Like there are people who come and visit their family and they need a place to stay. They want to be close to their family. They want to be close to their neighbors or in the same neighborhood that their family might be. Recently a lot of people are selling their houses and they don't have a place to go because their new house isn't ready or they don't have another place yet. Like there are reasons why people need housing for shorter periods than a year. And by doing this type of thing, I feel like the implication is broader than what is just, I have this goal in mind that I want to prohibit short-term rentals. Like there are people that are impacted by this decision that cannot be here now or can't rent here because of that. And I don't think it's fair for the preferences or displeasure of the few people, which, to be honest, I'm not really quite sure what the problems have been with short-term rentals. Anyway. But there are so many different reasons why people are staying and need short-term housing, and I understand that it might not impact you because it's not personal to you, it's not your family, it's not anybody here who may be impacted, but that is a very real reason why people are coming. And I also want to understand how, for me, my neighbor has my phone number and I'm happy to give out my phone number to anybody because I don't want issues at my property because I spent money to buy it. I don't want issues with damages. I don't want anything. I care about the neighborhood and I want to make sure people who are there are respectful and understanding of all the rules that I have in place for somebody to be able to stay there. So if there are any issues, then I want to know about it and I will address it before it even gets to the sheriff. I want to know because I will take care of the problem if there are any. And I have my info to anybody who would like it. But regardless of that, I feel like the best way to handle something like this is to include the people who oppose and support short-term rentals to come with an agreement that is acceptable to everybody, because it seems like decisions are being made because of the end goal to prohibit it, and decisions have been pre-decided. Even if we do conditional use, the decision is already going to be we're going to deny it, is how I'm understanding this. It does not seem
Well, we
fair
don't
or
have control
legal.
of what our zoning commission I mean, they're a completely separate board. So
Right.
it's not our decision to say it's denied or not. They are completely separate from us.
Yep, I understand that the board is a different group. It just seems like there's biased decision before a case has already been heard or anything has been brought up. But if there's any issues, like I want to address any problems that you guys have had with short-term rentals or, anybody to the public. But that's all I have.
Okay.
Thank you.
Thank you.
Hello, CJ Carr, 10403 Willow. Touch on just a couple of issues tonight. With the street or the illuminated sign issue, if you happen to leave here tonight, pull down out past Taco Bell, trying to pull out onto Montgomery Road, with traffic coming, with the bright lights flashing above you, with the sign changing there, I think that's Taco Bell on the corner. The illuminated flashing sign is bright as can be at night, which is the one issue that was being talked about. It's Royal Point. Royal Point's on the left if you're heading towards Fields Earl, but their sign's on the right at the intersection.
It's on the corner of Fields Earl.
Right there by Taco Bell.
That's where Taco Bell is.
Yeah, and that light up there, when you're trying to make a right-hand turn, when it's dark out in the evening, you've got car lights coming from one side, you're trying to pull out to see what's coming, and you got this light flashing over here at you with it changing words and everything.
Maybe talk to the zoning inspector about that?
No.
You're not allowed to have flashing signs, so.
Well,
It might
I'm
be a
not
zoning
flashing
cause.
it as it changes from
No.
whatever wording to the next. One's a bright white screen, and then, whatever the.
So maybe
It doesn't change quickly, it's just whatever the time period. But the brightness of that sign being on that corner.
So maybe we need to check and see if it's within the allotted light.
So that doesn't end up with these other, signs.
So Brian, how do we do that?
Well, that's why I asked if you had mentioned that to the zoning inspector. She can check it, especially if she gets.
She's not there at night.
She can make arrangements to be there at night.
Second issue just has to do with residential. I know it was brought up before in the zoning commission, and also the staff report is against limiting the number of structures to one structure or two structures depending on your lot size. Like you said, a gazebo, a shed, a kid's playhouse, anything that would need a permit, everybody's going to be in front of BZA trying to get approval for an additional structure.
It's already been.
Do play equipment account for structure?
Tree houses.
I believe so. With any accessory structure, you were limited to one.
Okay.
Well, it's detached structures. There are some that are exempt, like play equipment. I'm sorry. Play equipment would not count.
Okay.
Tree houses would count though.
If it's a structure that needs a building permit, it's not play equipment. We've gone through that before with the treehouse.
Third and final issue I've got, if I can drop these off. This is the copy of the interpretation that was mentioned earlier with section 171.10. In 2013, the township administrator at that time, this was brought up to his attention about rear decks extending into the required rear yard. Most yards are a little bit deeper than the C residential district, which is mainly Loveland Park subdivision and I believe in Camp Dennison, with the narrow depth on the lots. Our required backyard is 30 feet. That requires, according to the zoning code, a 10-foot deck. It was looked into in 2013 to extend the allowable setback to 14 feet into a required backyard.
Was that a variance?
No, that was this interpretation.
Okay.
A property owner wanted to build a deck that was 14 feet. went to get the zoning approval. It was denied because at that time it was 10 feet. Brian Eliff then, who was the township administrator, wrote this interpretation to allow for a 14-foot projection into the rear yard. Also, as part of his interpretation, it specifically spells out that no more than 10 feet in the front yard. The way it's being looked to be changed this evening is 10 feet in the front and in the back. And again, a lot of subdivisions, the rear yards are deeper than 30 feet. In the C residential districts, though, a lot of those rear yards are smaller. Multiple decks have been built in, I know at least Loveland Park, that are either 12 or 14 feet that are existing now, which are existing since 2013 when this interpretation was made by the township administrator at the time.
Okay.
So I guess we're just requesting that the 10-foot front yard setback no closer to the side yard than the allowable setbacks, wording is pretty much what it is now. If we could just get that rear yard setback to remain at the 14 feet, or if it's even just in the C district, if you want to get more specific. Because again, in the C zoning district.
Yeah.
Because again, a lot of properties have deeper lots, and you can build a 14, 16-foot deck on the back of a house without having to go through any, because you're not into that required backyard setback.
Okay. Thank you.
Thank you.
That's all I have.
I'm sorry.
Do
Do you have any comments to that, Brian? Do you have a copy of this?
Yeah. Yes, I do.
Any comments?
It was never 10 feet. I think that's what we suggested to Mr. Eliff at the time. He changed it to 14 feet. Like I said, I wasn't part of that. I wasn't aware why. Apparently, it related to a specific deck request that was in front of him at the time.
Okay.
I guess my question is this the general rule now?
Yes, that's
Yeah.
an attachment to the front of
Proposing
my code,
changing it
along
to
with
10.
all the other interpretations that
In the
Mr.
rear.
Eliff wrote.
Yeah.
It only applies to the rear is what the interpretation was.
Yeah.
Okay.
Okay.
All right. Anyone else make comment?
Yes, I'll just say that. My name is Karen Kane. I live at 10120 Meadow Knoll Drive. One thing that I keep thinking about with the short-term rentals is that it's a business, and I live in a single-family neighborhood. So these are investors who are buying property to make money. I mean, they're not doing it out of, provide housing, out of, people stay in short-term rentals for various reasons, but it's still it's a business, and they're being put in single-family neighborhoods. And I think that is a real concern. I think we sometimes get off track with how many days and the rules and regulations, but I think you need to really be focused on that. Do you want neighborhoods to change, or do you want to preserve the integrity of your neighborhood? Thank you.
Thank you.
Anyone else? Okay. All right. So should I close the meeting and then we should discuss it, or how should we go about this?
I guess what I would say is, if you close the public hearing, then you are required to make a decision within 20 days. You could make that decision tonight, or you could have a special meeting, but you will not be able to wait until your next regular meeting
Right.
to make that decision.
All right. I think do you want to close it? Hey, can we just, yeah.
What-
Do you have another comment real fast?
did have another comment. I thought
Okay.
it was in two sections.
Well, we haven't closed it.
Go ahead.
We didn't
Come
make
up.
it in two sections?
No.
Come on.
Come up. You want to give us your comment?
Okay, well, there's going to be hearing from the residents later.
Well,
Is your comment related to the text amendments?
Yeah.
no. Okay.
Yeah.
Okay.
Then there will be a hearing.
Yeah, there is one more.
All right. So I'll go ahead and close it.
Okay.
And now I'll open it up for discussion amongst us.
Well,
So,
Do we need to vote on closing it?
No. I
No, she
closed
just,
it. I just closed it.
the chair
I
just declared the
closed it.
public hearing is now closed.
Okay.
Okay, so I think we should tackle this one section at a time, right? So let's tackle section 31.3192 short-term rental.
Definition.
Definition.
Yeah. Okay, so the Regional Planning Commission recommended keeping the way it was written with the exception of reducing to 1 month. And the Zoning Commission recommended keeping it 1 year, but changing it from dwelling to single-family dwelling.
Okay,
Those are the primary changes.
so if it's going to affect our next section too, should we talk about them in a group?
Well, I think you need to define short-term rental, which we're attempting to do first.
Okay. Any ideas?
So if we change dwelling to single-family dwelling, then we have just cut out condominiums and apartments that are not single-family dwellings.
I don't know if we should do that, because what if, I think we should leave it open-ended, so we can apply it
Well,
differently.
we're talking about in the residential district anyway.
Yeah, but there's people in condos, I mean, that share walls and,
Right?
yeah. So you want to be able to have the same thing as a single-family area, I would think.
Yeah.
I think that shouldn't be single-family, I think it should be left as dwelling.
So that we keep it consistent
Right,
for residential.
right.
That makes sense to me.
Ken?
I'm not going to disagree.
Okay. Okay, time.
There's two groups say 1 year and one group says 1 month. I'm actually kind of in between. I think that legally you'd be hard pressed to limit any rentals to 1 year, because I know apartments and other things go to month to month or other kinds of scheduling. I heard the comment from the public about P&G or GE or somebody else putting people up in an area that they might want to move into later. That resonated with me, but I also know that those large corporations rent a place for a lot longer than a month for an employee. They rent it a year at a time, and then they have different employees fill it. Okay, so I'm thinking 6 months.
I'm fair with that. I think it's going to take away the partiers.
I'm willing to go to 1 month.
I'm okay with 1 month too, because I think that's going to take away.
Yeah. It would take away the 50 times a year rental.
Yeah.
All right, I'll go for a month.
Okay, 1 month. Okay, and then section 51.5, general provision. I'm kind of agreeing with conditional use, because then you can put limitations on it. I mean, if it's like totally inappropriate, they could deny it.
Right.
Versus saying no across the board.
I'd like conditional use also, and I think, on a case-by-case basis, when it comes before the Board of Zoning Appeals, I assume, right, Brian? That they will enact the appropriate restrictions.
And Ms. Symmes made some comments about adding some other things to that, Brian. Can you look at that?
I mean,
I don't know if it's appropriate since it's residential. I'm not sure. I mean, is that something we can look at and then? I mean, we always can come back
Well,
next week after everything's
Right, I guess,
been done
in
and
part, what I would say is,
redo
well,
it.
the public hearing is closed now, so you can deliberate things. And the only other thing I would say is, with any zoning resolution, there's a process that it can be amended in the future. So
Okay.
if you determine in the future that additional, some of the additional general criteria for conditional uses should be added, you can do a text amendment in the future.
Okay, that's fine. All right, so
I
we-
would be willing to go with conditional use, but I would like to include some details associated with that, kind of what you were alluding to.
Right.
I would like to actually document. We've already set the definition of 1 month. So I would like, with these short-term rentals, I would like conditions like a background check. I would like to know that general liability insurance is being procured. I would like people to abide by the parking, the lights, the signage, the trash, just like any other resident has to.
like, yeah, like you wanted a fence and trees. Yeah, those kind of things. So I think we're gonna have to have Kim hear us, rewrite this, and we might have to meet maybe next week because we're not gonna get the specific details. We gotta look into that, don't you think?
Well, it depends how specific we want to get. We could write it right now that a background check is required. General liability, I don't know what the limit of that insurance would be off the top of my head. We would need to define that, per occurrence and umbrella. We've already talked about the parking. You don't park in the front yard.
That's already there,
Yeah.
right? And screenage for people, backyard.
Well, what Brian
private.
mentioned that
Yeah.
as like a case-by-case basis from the BZA.
Yep.
Depending on who they're next door to.
Okay.
So can we include at least those two pieces of information, Jeff, in our resolution?
Can we allow people to get a background check? Is that, I don't know if we have the teeth to do that.
That's really up to
How are you
the
gonna
person who
regulate
owns
it?
the house.
I mean, it becomes, if it's included as a condition for the conditional use permit, I mean, I'm assuming you're saying that the property owner has to conduct the background check.
Yes.
And if
of-
that's
of
the case, then
short-term
it becomes an enforcement issue
Yes.
about,
Correct.
I don't know how we.
Who's gonna
I
enforce
don't know how
it?
you enforce it.
Well, we can't enforce it. We can't even talk about enforcing it until we make it something enforceable.
Who's gonna do it?
Well, who's gonna
We
check?
don't have staff for that.
I think, if I could, I think part of the issue, with that is the conditions that are generally imposed on part of a conditional use permit, they're imposed once, and then the owner has to comply with them. And it's fairly easy to tell if they have complied with those conditions. By requiring a background check, they would have to do that for every single instance that they want to rent that property. And if we're saying that it's anything less than 30 days, that means when somebody gets on a website to try to rent a short-term rental, they won't be able to do it unless there is a background check. if that's what, I think that's what I just want to make sure I understand what you're saying, is that they would have to do a background check for in every instance of everyone who's going to rent the property.
What makes this different is that we are talking about renting a property in a residential district.
No, I understand
commercial
what you're saying.
district or a
If
hotel
we have to
district.
rewrite this for you, I want to make sure we're understanding what you're saying, and that I think what you're saying is one of the conditions to get a conditional use permit is that in the future, for every instance that they want to rent the property, they have to conduct a background check. Is that
Correct.
okay? And I guess what I would say is then it leads to the same enforcement issue that generally you can say you have to, just to use the same example we've talked about, you got to put up a 6-foot privacy fence and plant 10 pine trees. That's easy from an enforcement standpoint because we can send an inspector out there and say, did they put up a 6-foot privacy fence and did they plant the trees? To impose a condition that every time they rent it, they would have to then, I guess, come back to the township to present proof of the background check.
It's probably not realistic.
I'm just speaking from a practical standpoint, from an enforcement standpoint, and from a, I guess just from practicality.
And here's another thing. If someone rents the property, are you getting a background check for everyone that comes along? I mean, are we doing that?
I don't think it's enforceable.
I don't think it's enforceable either. Just because the person who rents it might get a background check, but the friend might come over and are they getting a background check? I mean, I don't know how you police that at all.
Yeah.
And I wish we
Does
could.
Does Airbnb or any of the other rental agencies that a resident or an owner would go through have any requirements like that? They do?
Yes, we do.
Okay.
Who does that? Just so
Airbnb,
So Airbnb, if I would rent a piece of property, I would have to get a background check?
hypothetically. Hypothetically.
Property management companies run background
I don't think I've ever had anybody ask me for a background check.
I think it's hypothetical. I don't know that they actually do it. I don't know. I haven't rented from Airbnb, but
I mean, if your question is, are there services that perform background checks?
yeah.
Yes. Do long-term rental agencies perform background checks before they enter into long-term leases? Probably. I mean, a lot of this is speculation on my part. But again, to the practical aspect of it, it's one thing to do a background check on a tenant that's going to live in your property for a year, and then when there's turnover, do another background check. But this would, what I'm understanding is this could require background check every day.
No, every month.
No,
No.
Every day.
because they don't
If you're
have to
renting
rent
it for a month or
No,
longer.
no, that's not what you said. What the definition says, a short-term rental is anything less than 30 days. That was what what I understand is what you just said is a short-term rental is anything that's less than 30 days. It could be 1 day, it could be 2 days, it could be all 30 days.
Oh, well then
We're
we need to
thinking
write
longer
that.
than 30
Longer
days.
than 1 month.
Yeah.
So we make
you're-
the
Then I go-
definition of a short-term rental 1 month
Or
or
longer.
longer.
But then what you're saying is if it is for 1 day, it's not regulated at all.
It can't be 1 day.
It's
What-
1 month or longer.
But that's not what you're saying. What this is proposing to do is regulate short-term rentals. If what you're telling me is you want to define a short-term rental as something longer than 30 days, anything less than 30 days is not a short-term rental. So it's not regulated by this chapter at all.
So maybe we go back to 6 months.
But then it would be less than 6 months. It could be one day,
Anything less than
too.
6 months would be short, would not be short.
I think the way you have to look at this
And I gotta
is
look at how this is written.
that in general, you do not regulate rental property right now of any term.
Correct.
What you want to do, as I understand it, as it was initiated by this board and as it went through all of the various public hearings, is you want to initiate regulations for short-term rentals.
Yes.
So to do that, the first thing you have to do is define what is a short-term rental.
1 month or longer.
But that doesn't, but
1 month
then you
or
have
shorter.
left out anything less than 30 days.
1 month or shorter is a short-term rental.
Right. As you initiated it, this board suggested a short-term rental would be anything less than 1 year. That was what this board initiated. It went to Regional Planning Commission. They suggested, their recommendation was that 1 year is too long, that it should be 1 month. And if you really want me to make things really complicated, I would, if you want to be there, I would suggest talking about days, 30 days. If you say 1 month, I don't know if that's 28 days or 31 days,
Right.
but that's,
Okay.
we can, we can cross that bridge.
Good point.
So initially you said a short-term rental, the things we want to regulate is anything less than 1 year. Regional Planning staff recommendation was it should be a month. I'll take that as 30 days. That was Regional Planning Commission. They adopted that recommendation. Your Zoning Commission recommendation was not the 30 days. It was to keep it at 1 year. And what I'm hearing, the way this discussion started was maybe 1 year is too long and we should do something less than that. But you have to look at this in terms of fill in the less than, fill in the blank.
Right.
It can't be more than,
Okay.
because anything less than that would not be included in these regulations. It would be a free-for-all for anything if you word it in that way.
So we are at less than 30 days.
Well, it's less than whatever
Well,
this
7
board
months.
wants it to be. But I would suggest it be in those terms. A short-term rental is defined as whatever that says, any less than, you fill in the time frame.
Okay.
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 Are we finished with conditional use? Or are we still trying to put more conditions on? I do agree with the owner's proof of insurance for a rental property, because I think rental insurances are different than homeowner insurances.
So if we approve conditionally permitted use, then they have to apply through the township to go before the BZA.
Correct.
And the BZA sets rules.
On a case-by-case basis.
There are certain general criteria that apply to anyone coming in for a conditional use. The staff recommendation is to also add some other specific criteria. And then beyond that, any other conditions would be imposed by the BZA on a case-by-case basis.
So, for example, the insurance, the general liability, is that recommended by staff, or is that something that we need to incorporate?
It's something I recommend.
Yeah.
I'm not
Because
sure
I
that was.
recognize there's a difference in the type of insurance coverage required.
Well, there was.
No, that's not part of the criteria that Brian listed.
Right, there was, I don't think at regional planning or zoning commission, nobody recommended any type of liability insurance.
Yeah,
That
I
was,
think Ken just
Right.
wanted to
We're
add
bringing
that
it up
on.
now.
right.
Yeah. So can we make that a condition of the conditional use?
Answer to your question you're about to ask me, the letter is going to be I, to be added to the end of the conditional use
Okay.
list. So it's going to be added as I, little I, little I.
So, I mean, to answer your question, yes. There is a list right now in the code of specific criteria if you, that would apply to, that's in the code now. The staff recommendation is that if you were going to include this as a conditional use, it would be with criteria F, H, M, P2, S, and X. That's the staff recommendation, and what I'm hearing is that you would potentially like to add another thing to that list, which, as Brian pointed out, the next thing would be, II, and that could be proof of commercial general liability insurance, or whatever it is that the board wants it to be.
And then do we set the limits for that insurance later?
Well, I mean, that's the question, if this
Well,
board wants to even set what the, I mean,
the insurance company's going to set the policy and the cost.
well, generally, it's between a property owner and the
Yeah.
insurance company
We
of
just
what
wanna
they
make
want.
sure it's of the right category.
I think what I'm hearing is you would like a requirement to be that they have and maintain that insurance.
Yes.
What the limits are
Yeah, we can't set that.
would be between the property owner and their insurance company.
Yes.
I don't know enough about, general commercial liability insurance to speak to it at all.
I was told by an insurance agent that there is a difference between just a regular homeowner's insurance and a rental property
Yeah,
insurance.
sure, I believe that.
Okay. Okay. I
So
just
I
wanted
have a-
noted.
So we put all these conditions. So what if they violate the conditions? What happens then?
I assume then they're sent a notice of violation, and it would proceed like any other violation under the zoning resolution,
Right.
And
which I suspect
Well,
could result in
when
the
they come in and
revocation of
apply
their
for
conditional use permit.
They have to meet these requirements, which means if they have to provide an insurance policy or something that basically says they're covered under these conditions.
Okay, I agree with the insurance policy. I'm just trying to figure out a way that we can make sure the people that are coming in are safe.
Well, we're not going to know that they renew it on an annual basis unless they had to come before the board on an annual basis.
Right.
But we would know up front. That's the best we can hope for, I would think. I'm sorry, that the BCA would know up front. Okay. Any other restrictions, Phil?
Not that I can think of right now.
Yeah.
Okay. But any others
This
could
is
be
gonna be
added by the
rewritten and we'll come
BZA
back, right?
on a case-by-case basis.
Yes.
I mean, that's what you want.
I mean, if that's what the board wants, it's up to the board.
You're gonna have to table it and then.
Well, right, that's why I said that if you close the public hearing, then you'll have to act on this within 20 days.
We understand that.
What are you telling me?
What's the
We're not gonna
question?
Go through the rest of this? It's taking
Yeah,
too
no,
long.
I think we should go through this, but what I'm saying is, I think it should be rewritten and then we'll just come back and make sure, because we're kind of stumbling through this. Do you
Well,
understand what I'm saying? So we know
alright.
exactly
But we would
how
have
things
to-
are gonna be written and how things, so we can mull it over.
Okay. but
Does
we
that make
would-
sense?
Yeah, but we'd have to, what?
Act
We
within
would
20
not have
days.
another public hearing, we'd just present what we're gonna do.
Yeah, just like we did last time.
You
get
have
it
20 days to
organized.
make a decision if you table it. If you do not vote on it tonight, you have 20 days, just like we did
Yeah,
last month.
that's right. Yeah, we know that. So what we're getting is what we're reading in front of us, because I got a lot of scribbles going on here. Does that make sense?
Yeah.
Okay. All right, so,
Okay, we keep going.
yeah.
All right.
Section 137.3, height and area requirements.
I have a question of Brian, if I may. If we were to reduce the parking area setback from 20 feet to 10 feet, can I do that?
I'm sorry?
Clarification? I mean, hearing's closed, but I had a question.
You can talk all you want.
I mean, the public hearing is closed, and the board is free to deliberate this all they want. I mean, generally, what I would say is, I mean, if you're asking me, you can ask me legal questions, of course. I mean, if you're asking staff for some kind of clarification, I mean,
No building shall be.
it's not what you shouldn't be relying on it for based on any decision, because any decision should be based on what was heard in the public
Just want
hearing.
clarification.
I guess ask.
Okay. If we were to reduce the parking area setback from 20 feet to 10 feet, knowing that we currently have a 20-foot setback, which also requires 10 foot of buffering, okay? If we move from a 20-foot to a 10-foot setback, would we have any buffering requirement?
Yes, you have a 10-foot buffer requirement.
Thank you.
So,
Okay, that's all I wanted to know.
okay, so I'm okay with this one.
I'm okay with it too.
I'm okay with it now that I know that there's still a buffering area.
So, section 143.2, shared parking modified. I'm okay with this one too.
I am too.
Okay.
Ken?
Question.
I'm sorry. Can we go back though? So on 137.3,
Yes.
are you saying then that you are? I didn't understand where you came out on that. Are you?
I'm agreeing with the way it's written.
Right.
And-
Agreeing with staff
With-
recommendation
with-
to add all those additional sections to the parking requirements for all
Correct.
sections
Right.
listed for 94.5, 104.1, 105.2, 115.2, 124.4, 134.5 et cetera?
Yeah.
Yes.
You're okay?
Okay,
I'm
so
agreeing
so
with-
you're
with the
accepting
whole
the
thing as
recommendation
written.
from
As
Regional
far as I
Planning
was
and Zoning
concerned,
Commission?
The only
Yes.
issue was the
We
just-
setback change from
I want to
20
make sure
10
we
feet.
have the right version of this.
Okay.
Okay.
And then I'm accepting from Regional Planning and Zoning Commission their recommendation for the shared parking.
Okay.
Are you okay with that?
Yes.
I'm okay with that. And there are only two word changes in there. Yes.
Okay, section 146.1, outdoor lighting modified. Okay. So, we know most of the places have 24 foot, right?
No. Most places have 15.
Yes, but most
But
of the
we've
places, yeah.
approved a lot of variances at 24. But to Mrs. Symmes' point, all of those were in industrial areas or commercial areas.
Is that, I wrote that down, but is that a fact? They're all in commercial?
Well, the ones listed here are, I
The
believe,
variances?
Those are all existing light poles
at 24 feet.
at 24 feet.
Okay.
And they do have to have a light brightness requirement on them of 0.5. I got that from Brian. So they can't be bright.
Right, we've never had a request to come in and remove the 24-foot light pole and replace it with 15. Everybody always just asks for a variance.
Right.
But this doesn't say whether it's commercial or residential area.
Well, it can't be in residential, can it, Kim?
Well, it says outdoor lighting. It doesn't tell me what the zoning is.
It's just commercial, right?
It applies to churches
Oh,
and
applies to all
institutions
that.
and
Okay.
residential districts. It applies to any parking lot that has outdoor lighting.
Can we just make it for our commercial areas, not churches? Is that possible, Brian?
Yeah.
What do you think about that?
I'm okay with 24 feet in commercial area.
Commercial areas, just commercial areas, right?
Right.
It would say no greater than 15 feet in residence districts or 24 feet in the O and E residence districts.
Yeah.
Okay.
Okay.
Well, in non-residence districts. That would be the H, O, E, F, and G.
We're sorry this is dragging out. We're trying to make sure that we get it all figured. Okay.
And emphasizing that the light ends at the property line.
Right.
I know that's in our code, but I don't know if there's a way to emphasize that in this.
Yeah. Okay. Is that okay then? Are we
Yeah.
ready to move on? Okay.
Just remember, residential districts include parks.
Okay.
Yeah, so we don't necessarily need them, but we could apply
But
for a variance.
we
if
control how
Right.
close the poles are to each other and everything else in parks, right?
Right.
Just remember, you have baseball fields.
Hmm?
Just remember, you have baseball fields.
Oh, is that an exception?
It
We have
applies to
light
all.
poles more than
But we
24
have,
feet
we
in our,
don't have, we
in
have
our
15
baseball
feet
fields.
right now, right? No one's asking for 24, right?
But
our
we already
basic-
have existing poles in the baseball fields that are taller than that.
They're taller than 24.
Yeah.
Yeah,
So I'm just reminding you of that.
okay.
Okay.
Will we be grandfathered in?
Well, yes, because
Okay.
they're already existing.
Thank you.
Okay.
All right. All
And we'd
right.
have to ask for a variance in our own parks if we were to put in more ball fields lighted. I can live with that.
Brian, is that sound okay as far? I
These are all
mean, is
conditional
that,
uses. They've all gone through conditional
is
use
that like a
approval.
normal thing?
For the light poles and baseball fields to be taller than 24 feet, yeah.
Okay.
It's a conditional use to add, to install a new baseball field in a residence district anyway.
Okay.
All right.
All right. Section 171, additional use, height and area regulation and exceptions. So I would agree, the zoning commission agreed, and the regional planning agreed, so I'm okay with this.
Which one?
171.
171.
Additional use, height and area regulation.
That's the one where we have this opinion.
Correct.
Of the 14
14
foot
foot.
Oh,
in the rear.
okay. So do we want to
Kim?
make exception for that
So it'd be
area?
10-foot front, 14-foot rear.
So that'll take care of Loveland Park's problem, right?
Is that okay, Kim?
I don't agree with that. I just don't agree with making one section.
But we already have an exception.
You have exceptions everywhere. You could use that other argument the other way. If you push that to 14 feet, that means that 30-foot setback just became 26 or 14 or 16 feet. I can't do my math tonight. So if you live behind them, you have a setback of 16 feet. I don't agree with that.
16.
Well, I didn't notice
I don't
that.
understand 16 feet.
What's that?
I don't understand the 16 feet. Where's
If
it?
you have a 30-foot setback in your house, you have 30 feet from your back of your house to the back of the lot. If you're allowed to build a deck,
30-foot setback to me means from the front, not from
no,
the
no,
back.
no, no, you have a rear and a front.
Okay.
So you have 30 feet or whatever it is in the front, and you have 30 feet in the back. So if you have, from the back of your house, you have 30 feet. If you put a deck on your house, what you're saying with the 10 feet, your backyard now becomes 20 feet with that new setback. So at least there'll be 20-foot setback if you back up to that person behind you. If you let it go 14 feet, now that 20-foot setback just became 16. So it's just an encroachment into the rear property line.
But let's say somebody needs a 14-foot porch on the back.
Then they can come and ask for a variance.
Okay. And how was the 14-foot example we were given, how did that come to be? Was that
Because
Moved
our
at a
code,
BZA?
no,
or
our code does
by
not
minute?
specify any setbacks. So Brian made an executive decision
Okay.
as the zoning administrator and wrote an interpretation.
Brian Elliff.
Yeah, Brian Elliff, the guy that was
Okay.
here before me.
Right.
So we never saw this.
I didn't know it existed until the zoning commission meeting.
So,
I remember him writing interpretations
I don't know. I mean, I'm not gonna speculate on it. I'm just saying,
I do remember him.
the way I would have handled it is you go to the board and you go to you guys and say, hey, we don't have this in our code. It needs to be changed.
okay, so
So what is the normal setback?
So the one
Normally,
that's in-
10 feet
the
is a
one
normal
that's in-
setback.
The one that's in is 14 feet,
Bless you.
right? We only have one that's in 14
Oh,
feet?
I'm sure there's
Numerous.
varying
Right.
degrees of
Okay.
setbacks all over the place that we've just never caught. Or we've given a variance to, or all the above.
So what you're saying is we should probably leave this as is, because if someone wants to build a deck, let's just say in Loveland Park, they can build a deck and the person behind them won't have the say that.
Well, they can
it's,
also build a deck, so then you're reducing that
backyard.
Yeah, backyard by
But if
even
they-
further.
But if they agree that they don't care each other has the deck, that's one thing, so that would be conditional use. But if one person is
No, it's
like,
not a conditional
they
use.
should be able, right, they
This
should
would be allowed
variance.
by text.
Right, so what I'm saying is if they have to come in and apply for a variance, the neighbor would have a say, not yes or no, but they would be able to say, no, I don't want that,
Right.
versus now they wouldn't have a say.
Right, because right now the interpretation is 14 and 10.
Right.
So we've not had a requirement for the backyard? or we
No,
have?
it's right, it's not written in the code anywhere. That's why when,
Okay.
Right.
That's the issue. The code was silent. Apparently, some years ago, the zoning administrator made an interpretation,
Okay.
like he would have to do, and his interpretation was 14. We don't know where that number came from, other than there was probably, the deck that was in question was probably 14 feet. So
Yeah.
that's where they got that number.
Okay,
So
and
all
we
this
don't
would
know
do.
that in that particular case, they still didn't meet the 30-foot setback in the back.
No, they.
We don't know that.
Well,
then he
right,
said-
and we're not, we shouldn't really be talking about specific applications. The question here is, the code was silent about the encroachment, and we should maybe stop talking about the setback, because what this is really talking about is how much you're allowed to encroach into the setback. It was silent. What's being proposed, what was initiated by the trustees and was, which is recommended by both other reviewing bodies, was to make it 10. And that would be consistent with the same encroachment in the front.
Okay, so then if we make it 10 and someone wants it 14 or whatever, they just come and apply.
They
in
ask
front
for
of
a
the
ask
zoning.
for a variance.
Okay. All right, since there's no objection either by the zoning commission or by staff at the 10
Or regional planning,
regional planning, whatever.
yeah.
Okay. And I'm okay with it,
Keep it 10.
10 feet.
Yep.
But what we're doing is we're putting in there front or rear.
Correct.
Okay.
Okay.
Which is also consistent with Hamilton County zoning.
Okay.
Section 320.4 variable message center for signs in the O or O district. Okay, so refresh my mind. O is what?
Office.
Office, thank you. And O is
Plan Unit Development Office.
what?
Plan
Good.
Unit Development Office.
Give me an example.
Union Savings Bank. It's a
Union
plan unit
Savings.
development. So anytime they would have to get a zoning certificate, they'd have to go through the zoning commission to get a final development plan. Anything that has a double letter.
Okay, so it's, from what I'm understanding, we're granting them. Is that correct?
So this would allow for.
Yeah, but I mean, if they come in front of us, no, we are not if they can't come in front of the zoning.
Yeah, right now, they're not allowed in an office district, period.
So they can't apply.
No, they can't get, they would have to either get a variance from the Board of Zoning
Right.
Appeals, or in the OO, they would go to the zoning commission because they'd have to get approval on a final development plan, a modified final development plan.
Okay, and are we granting them if they come in front of us?
Well, this text would allow them to have that ability to get a ground-mounted variable message sign,
Right.
just like we do in the residential districts. They would have that ability now, if you say yes to this text. Ground-mounted only, and it would be the 25%. And then the zoning commission recommended that we add number 7 with the dimmers.
Where does this say ground mounted only?
Let's see.
It's a different section.
Yeah, it's a definition.
Okay.
Where it says section 320.4-1, in the last part of the sentence, it says freestanding ground-mounted sign.
The last section.
$25%.
Huh? Where is it? Which section? 5, 6, 7?
Auto dimming. So the auto dimming photo cell, do we have the maximum bright it could be at night, or do we have, is that defined?
It's not defined, is it, Brian? The brightness?
Should we define that?
It's defined in the section.
Can we define that?
I don't know how you would.
I don't know any number for that.
I thought you said it was 0.5 foot candles at the property line.
Property line is allowed to be 0.5 foot candles, is what we've always done there. I've seen others where they talk about nits, I think that's what is being suggested there. Night levels at the actual sign, that is regulated. Actually, we don't have a nit detector. On the signage, so I don't know how we would administer that. We do have a light meter that we can use at the property line, and that's what we've been doing, and that seems to have worked.
Okay. So regional planning said it was okay, and our zoning commission disagreed. Is that what I'm getting on this one?
Yes.
Okay. I'm okay with the way this is written.
Including the number 7, the addition of the dimming photo cell language?
Yes, I would want that.
So is the foot candle restriction, is that
That's on everything.
specifically defined?
In the lighting.
Yeah.
So that would by default then apply?
It does already apply.
Okay. What are your thoughts, Ken?
Yep.
Actually, I see the greater need for variable message signs in the O or double O district than I do in the residential district. So,
Yeah. You guys got to make a decision what you want to do.
display interval. Display interval. Which is 3/10 of a second or less.
It's supposed to be 3 seconds. Is that right?
The other way around, it's supposed to be 3/10.
It's supposed to be 3/10.
It's supposed to happen, yeah, so it's a long time to fade.
Well, 3/10 of a second is like
It's supposed to be
flashing.
instantaneous.
It's like flashing, and
No.
we're trying to keep it from flashing, right?
Each message has to be displayed for 8, 6, 7, whatever the number is that's in that section. And then when it changes, it has to change.
Oh, okay.
I see.
So the time interval for change is 3/10 of a second. Okay. So it's not spread out like.
Yeah, that was confusing.
Okay, I understand. Thank you.
Yeah, I was confused
All
by
right,
that.
what do you
too.
think, Phil? I don't know.
I think we keep it consistent.
Okay. So you're in favor of the way it is?
Yeah.
All right.
Okay.
Okay.
All right, so
Next.
then we're mix this. Section 321.4, wall signs with E and EE districts.
Delete.
We already deleted that one.
No, we didn't.
I
We're
deleted it.
discussing it.
Okay.
I don't know if you guys, since there was support in neither board, I just deleted it from the resolution.
Okay, so that one's deleted?
Right.
So
If
we're-
you
Well-
agree with me.
I recommend I
Delete
agree
it?
with deleting it.
Okay,
Okay, I agree.
all right. So section 321.5, variable message signs in the E or EE districts. Didn't I just read that one?
So the
That was
change is
modified.
here 50% versus 25.
Correct.
And freestanding pole sign up to, oh, that's square foot. Okay.
Yeah, get rid of the square foot.
Yeah, and
Doesn't
I
make
agree with
sense.
what the zoning commission added.
Okay. All right.
And then the last one would be section 351, detached garage storage structure and other detached structures.
Delete.
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 And I deleted that one too.
Okay. So
Okay.
we all agree to delete that one?
Yes.
Okay.
All right. So what we're going to do is we're going to have this rewritten, and I guess we need to come up with a date that we can get back. We can read it and make sure it's exactly how we want it, and then we can vote on it. Okay?
Within 20 days.
Well, yeah.
Because it is subject to a referendum, so it's important that it's here.
Okay.
Mhm. So,
Wednesday.
pick a date.
So wait, where are we?
We're done.
With, in their discussion, so now do we move on to resolution 22-52?
We will, but I
Okay.
think they're talking about a date
Yeah,
when
reconvene.
we can reconvene.
Okay.
Yes. So does next Tuesday meet the criteria?
Oh, I can't do Tuesday.
I
Okay.
can't get a legal ad that quick.
How about Wednesday, the 11th?
It
Still too
depends when
quick?
she can get out.
Or do you want to look at the next week?
How's my calendar? And there's the calendar.
That
20
could be the
days
week-
puts us at the 23rd.
Yeah, I was going to say, it could be the week of the 16th.
It can't be on a Tuesday.
Can't be on a Tuesday. Okay.
That's not
How about
Thursday.
Can't do
Monday?
the 18th because there's a zoning commission meeting that are already that night.
Okay. How about Monday, the 16th?
I'm clear.
Monday, the 16th?
Does that work for you?
Can you get that ready?
That work,
Kim?
No.
16th.
Can you do the 16th, Kim?
Yeah, I was just questioning, do I need a 10-day notice for the notice in the paper? And Jeff says no.
Well, it's not a public, this is not.
It's not a public
It's
hearing.
not a notice of a new public hearing.
Okay.
This would just be the regular notice of a special meeting of the trustees.
Which is 24
Which is
hours.
24 hours.
Okay.
Heightened Township just sticks it on the
16th?
door. That's how they notice it.
You can't be-
Are we
Okay,
doing-
Jeff
But
can't.
I don't have to.
Jeff can't be here. I don't know if that means anything to you guys, or,
Well, we can, whatever. I don't know. Does it matter to you guys?
I don't know. I'm afraid to have it without you.
Okay, so then let's move it. What day can you be here, Jeff?
What about the 19th? What about the 19th?
What day's the 19th?
It's a
Yeah, I can do that.
Thursday.
Thursday,
Yeah, I can do
Thursday.
that.
I can do that.
Okay.
19.
Can we do 6 o'clock?
Yes.
Yes.
Is that okay?
Okay.
Do
So
we
we're going
want-
to try to
do
get
we-
everything straightened out. We're coming back on the 19th
Do
at
we
6
want
o'clock.
Brian?
Brian.
Do we want Brian to join us?
Right.
Drinks closed, right?
Really,
I'm just
there shouldn't be any need for Brian to be there, because all you'll be doing, I mean, it's just a special meeting for you to actually take the final vote on it.
Right.
Okay.
Okay.
And then Ken.
You're welcome, Brian.
Approximately
Poor
when,
guys. You've been sitting here all.
approximately when can we rewrite this and post it
Oh,
on
I'll
the
try to do it
website?
tomorrow, at least by Friday. I'll try to get it done by Friday.
Okay, and post it on the website. Okay.
Okay. So we're all good. So they need a table, though.
Yeah.
Yeah.
that's Right.
I move to table. Do I have to reread the whole resolution?
I would read.
I mean,
Read it?
you can read the title, and then you'll need a motion to table it until whatever date we just
I move
picked.
to table let's see, where's my resolution? Hold on. Approval of resolution G20-2022-52, resolution to approve text amendments to sections. Do I have to reread the whole thing?
Yep.
Is that good enough?
I mean, that's what the resolution pertains to, are those sections.
Yeah. So do I have?
Okay, we're talking about resolution 2022-52.
Yes.
Yes.
Okay, and
I'll reread
that's
it.
on, no, it's okay. It's on the agenda for consideration tonight. What I'm hearing is you'd like to, that you would entertain a motion to table it until,
Thursday, May 19th at 6 p.m.
yes.
Second.
Roll call.
Ms. Lees?
Aye.
Mr. Bryan?
Aye.
Mr. Beck?
Aye.
Okay. I move approval of disbursements warrants 80998-81127 and voucher 7496 in the amount of $337,262.04.
Second.
Roll call.
Mr. Bryan?
Aye.
Mr. Beck?
Aye.
Ms. Lees?
Aye. Reports. Law Director.
Thank you. No report tonight.
Police.
I don't have anything. I'm Lieutenant Barbara Stuckey. I'm taking the place for Lieutenant Tarr. I would like to say something as far as for the general public. A couple things are starting to happen. Obviously, the nice spring weather and everything, we're getting a lot more reports on the west side. I'm not sure as far as what's happening on the east as much as far as car break-ins. Things that, valuables that you leave out. We just had a rash of purses being taken out of cars. They're smashing the windows because they see the purses laying in the front seats and things like that. So just a general reminder, put your valuables in your trunk or out of view so people don't see those. Another thing, people are starting to go on vacations. Remember that we do vacation checks. So make sure you call us at 825-1500, 513 for the area code. So thank you very much.
And thank you for being patient with us tonight. Okay.
Good evening, Board. You have our written report. I'd also like to update you on two programs that we have going. We've been, you may have seen our crews out doing the Smoke Detector Blitz program, where we've been sending crews door to door with the goal of trying to get smoke detectors installed in every home. We've completed Pemmican Run. Camp Dennison, I believe, will be completed this week. And we have been sending out mailers ahead of time where we're going to try to make sure that we can get in touch with the people. So they will be home, and we'll be doing this through August. So if you see our crews out, and I look forward to to getting smoke detectors installed. And the other program that we have is Safety Camp is coming up next month. So last year was our first year for it. We had 55 campers, which was a pretty good success, but we weren't really sure how we were going to be able to handle that. And we have increased our capacity, and we're up to, as of today, 106 registered. So we've almost doubled it. We are going to close the registration at the end of May. So if there's any residents that would like to get their kids registered, we have till the end of May to get
When
that
is
done.
it?
It's June 3rd, 13th to the 17th. So it's 5 days. It'll be at 7 Gables Park. That's all that I have, unless there's any questions.
Thank you. Director of Public Works, Bill's not with us. There are no committees. Other, there's none. This is where we go back into hearing from residents. So if anybody would like to speak, please come up and state your name and give an address, please.
Mark Llewellyn, 9355 McKinney Road. I'm concerned about the tabling of the vote for this hearing on the Snyder Road development. I heard a resident say the hearing was not closed. I went back and looked, and in fact, it was closed. So we did that right. When the new date was picked for the vote on that zoning change, you trustees, the administrator, and I'm not sure the law director was here or not, no one picked or caught, and I've heard it 5 times tonight, about the 20-day rule, which is Ohio Revised Code. And it really irks me that the leadership of our township, and again, I apologize because I don't know if you were at that hearing.
I was here.
Were you? No one caught that we were going to be outside the 20 days. Tonight, all we heard about was the 20 days we have to be inside of. So I'm really disappointed that all the brains of the township, nobody thought to even consider the 20 days.
Did we meet the 20 days?
You did.
Thank you.
Hold on just for a second. I lost where I was. I'm concerned, I won't say it was intentional that nobody was on the ball to do that. But what does concern me is it left the door open for a challenge. If the special hearing, I understand that a resident sent an email to make it clear, hey, you're not going to hit the 20 days. And that within 24 hours, the special hearing for the vote was then put in place. The concern I have is that if the 20 days had not been hit, it would have left the door open for the developer and his attorneys to potentially sue and challenge the township for the zoning change. As I recall, the same thing happened in the summer or fall of 2020 in regards to the last text amendment. And I'm shocked that nobody caught it as you guys were deciding to table. The other thing that concerns me is Mr. Beck's comments that night, on the night of the vote. I feel that he made recommendations and suggestions for the developer that would be acceptable to him. When the only thing you guys, as far as from my perspective, were here to do that night was to vote on the resolution in front of you. And the dissertation went on and on about, oh, the developer can probably do this, and I would consider voting for something like this, and so on. And it bothers me that that's nowhere in the scope of what you guys were voting on.
Mark, I think when we are discussing it, we can talk about options, and I think that's what Phil was doing.
Right. We can approve it as amended.
Yeah.
Okay.
Or we can modify it, and I think that's all Phil was doing.
So I said I was clear that what was being asked for was too much, and that was the general feeling. Okay?
Okay. That's fair enough.
Yeah.
I just want to voice my opinion because I think it's important, and I think that, you know, like I said, I'm really concerned that nobody caught the 20 days when you were setting up the date for the vote.
Hey, you know, I'll be the first to admit we're not perfect.
Right.
But at least the takeaway for me is when we recognized the problem, it was fixed right away.
Okay.
Yeah.
Fair enough.
Thank you.
Carol Symmes, 9972 Washington Street. What Mark was referring to is the fact that I brought up to this board, and I stated and gave you timelines that the text amendment that you were adopting, you had not scheduled your public hearing within the agreed code, the ORC code. And what was I told? Oh, we talked to our attorney, and he said, we are fine, it's fine. And I think, Jeff, you even said, oh yeah, they're fine, they're within. But now all of a sudden, book, Snyder, 20 days, now 20 days. So why was the text amendment before when I said you guys were out of line? I was incorrect. Because they were way over 20 days. Even the zoning commission was over the limit. That's fine, you don't have to answer my question. I made my point. Also, why do you have a zoning commission? Your zoning commission recommended denial on 4 items tonight, and you totally ignored their recommendations. Even to the point, your administrator was already deleting 2 sections. When was she told to delete those sections? How did she know you guys were not going to approve those?
That was her recommendation.
She said, I deleted those. I've already taken care of those. I deleted those.
That was her recommendation.
Let's go back to the variable message signs. Variable message signs. You initiated that zone change because of Union Savings Bank. There's minutes, there's statements, and everything that agreed. I'm speaking. In the minutes of the zoning commission, Mrs. Lipinski states that the reason this came about is because U.S. Bank had a VMC on a wall sign that is not permitted in O districts. She stated that the sign no longer works and they want to replace it. She stated the bank asked how they could replace it, and the township told them they can't replace it unless they get BZA approval to do so. This is in the minutes. This is what she told the zoning commission. She said that they, U.S. Bank, reviewed the BZA meeting minutes and thought they had a better chance of getting signed if they asked the trustees to change the text in office district.
Well,
She
no
stated
one
the
asked
I'm
us.
speaking. She stated the trustees reviewed and felt they wanted to be consistent and initiated change to make VMC on ground-mounted signs instead. You had already made up your mind that you were going to approve VMC signs in the O districts.
No.
Why you had a public hearing, why you allowed the zoning commission to do it?
That's not
doesn't-
true.
It is true.
No.
It is
How do
true.
you know that?
How do you know that?
How do you know
That is
that? You
hypothetical.
stand there and make all kind of statements
I
and you
can
have
make
no
all kinds of
basis for
statements,
half
too.
of it.
That's not
Mrs.
the
Lee
case.
shows concern if the text amendment fixes the issue with U.S. Bank. The administrator stated would allow them to have a ground-mounted variable message sign. That is in your February meeting.
Go on.
It's in your minutes. It is there. You have made the decision.
Carol, that doesn't necessarily say that we're changing
Why are
our
you-
zone. Would you?
I'm
I'm talking
sorry.
now.
I stopped. Go.
Just because we realized that our code might have been too restrictive and we change it. And I made a comment saying, does that fix the problem with US Bank too? It doesn't mean we're changing our zoning code to fit what US Bank is asking for. We were just, the problem was brought to our attention and we tried to fix it. And US Bank happened to be the one that we fixed it. Do you understand what we're saying? We don't go through these codes and make it fix because someone makes a phone call to us. We are made aware of a problem, and we're trying to fix the problem in general. And coming in here all the time, just attacking us, it gets old, Carol. Because it's very frustrating because the negativity and the nastiness that you bring to us sometimes. You can voice your opinion, but it doesn't have to be as an attack, as angry, as I don't even know how to describe it. It just wears on us.
Are you done?
Yes.
Okay,
I'm done.
thank you. Thank you. I'm upset simply because I see things being done that just don't make sense. And I have the right as a resident to come here and voice concerns. And for you to agree, why do you have a zoning commission if you're going to disagree with the recommendation?
We do not have to go along with everything they say. We can have our own opinion. They're an advisory committee to us on these issues.
They're a
okay?
statutory commission.
All right, but
let's forget about that. Yeah, so Union Cemetery, now they don't have to come before zoning to do a modification because they can have their old office, their VMC sign. And do you understand?
It's okay.
Just picture going down a road that is full of doctor's offices and everything, and now you're going to see variable message signs. You open the floodgate to allow variable message signs in residential districts. And now you just allowed anybody who wants a variable message sign in Symmes Township. Where is your
You don't think a church has a right to have a variable message sign?
not a variable message sign? No. No.
That's your opinion.
And it's your opinion that you approve it. You're destroying the residential character of the township. You're allowing higher light poles.
That's your opinion.
I'm not talking to you. I'm talking to the other.
I'm talking to you. I listen to you a lot.
When was the light poles at HOB, the home of the Bray Park, approved? What conditional use did you go through to get higher than a 15-foot light pole? You didn't go through any. You just put up the poles. Correct?
Kim? I don't remember.
You didn't.
I don't remember.
You didn't. There is nothing before BZA on your conditional use, which a park is a residential, and a residential district has to go before conditional use. You didn't go through that. And when I sat up here and just said to you, you didn't follow the ORC code regarding your time frame for text amendments and hearings. And you were told, the attorney said we didn't have to do it. And now all of a sudden, it's got to be 20 days. We got to do 20 days. We got to do 20 days.
We go on our advice of our attorney.
And your attorney said previously, it's okay, you don't have to do it. And now all of a sudden it's 20 days.
I don't know what to tell you.
So did you finally read the code, or what made you change your position from that's okay for them to be way over date, and now it's 20 days? Seriously.
I just said I'm not engaging with you. This is your
That's
opportunity
fine. That's
to
good.
address the board.
That's good.
Feel free to address the board.
I'm addressing the board. I'm addressing the board. I can ask you to reconsider the VCM in office districts, but it's not going to do any good. You're going to have signage all over this place. When the zoning code was adopted in 1996, that was one thing we changed. We changed to control signage, to do away with billboard signs, to do away with the high-rise signs. And now all of a sudden, we're having all these electronic signs all throughout.
It was 1996.
That's true.
It's 2022.
And the residents voted on that zoning text amendment in 1996 based on what they were promised. Better control of signage, more control over the business areas, more of a residential character in Symmes Township. And it's like you guys don't decide that. You don't care anymore. That's my opinion. And Jody, for you sit there and roll your eyes, you need to separate.
Because Carol, one thing I have to tell you is I care about the township. And I get tired of you coming in here and telling me I don't care about the township and I'm not doing this and I'm not doing that. It's wearing. It's my opinion. I'm allowed to have an opinion.
And I have an opinion.
I am a trustee. I've been
That's my
elected by
opinion.
the residents of the
But you
township
need,
to have an opinion.
you need to separate me as a resident from the Symmes Township Historical Society, because you are punishing the Historical Society, because you can't separate me and CJ from that organization.
What are you talking about?
You know exactly what I'm
No,
talking
I
about.
don't know what you're talking
You know what
about.
I'm talking
Oh,
about.
yeah, okay.
CJ Carr, 10403 Willow, here in representation of the Historical Society this evening. First off, I'd just like to say that we had a meeting, myself and one of the trustees and staff, and I think we had a good meeting out at the log cabin site, worked out some details, and plan on having a good cooperative year coming up for the benefit of the township park and also for the public. With that being said, we are planning on being open starting in May here, the first and third weekends of the month, May through September, 1 to 3 p.m. on Saturdays and Sundays. We will also be open coming up later in May during the storybook presentation by the library and on different times through the summer, which you can find out on our website at Symmes Township Historical Society.
And I'm sorry, see, you said first and third weekends, 3 p.m., Saturday and Sunday?
First and third weekends, 1 to 3 p.m.
Oh, sorry.
Through September.
Through September.
1 to 3.
Starting this weekend. This weekend will be the first weekend that we're open.
So both days, Saturday and Sunday, you said?
Right, Saturday and Sunday.
Okay.
That is subject to change a couple of holidays depending on the 4th and Labor Day. We move those around, but again, those dates will be updated on our website when we change those around.
Great.
Question, it was mentioned by Mr. Grossi in the beginning about the records retention and turning over to historical societies. What is the process?
State Historical Society is the recipient of all public records after certain periods of time defined by schedules.
Right.
And what they were referring to is they put together a schedule called RC2.
Yeah.
And it was approved at the state level that schedule was good, and we're attempting to follow it now.
Is there a way to give those to the Township Historical Society to keep as records of the township, or how does that proceed from there?
I don't want to misspeak, but my gut feel is that it's a process set up through the State Historical Society, and any deviation from that would have to be requested and approved.
And
I don't know that it's possible, but I don't know the answer.
You know the answer.
Well, I think, let me be clear, the records, the township records don't go to the State Historical Society. It's just, it's a list that says, here are the types of records we have, here's how long we're going to keep them before we can get rid of them. That's the only thing that went to the state, was the schedule. And if you're saying, would you guys like to see, would you like a copy of the schedule? Is that what you mean?
And/or record, just to keep track of records from, past. When I do research on things, I go to different places, the library downtown, different historical societies have different things. I just caught the phrase of historical society when it was started.
Right.
I wasn't sure exactly
Right.
what
Now
it
that's
was going
like the trustee said, it's set forth in the state law. It just talks about you have to create this schedule of how long you'll keep the records, and then you send that to it's actually the Ohio History Connection now, I think. It used to be called the Ohio Historical Society. And they approve it, and the state auditor approves it. All they're really approving is the time period of how long we will keep records. That schedule, what's called an RC2 retention schedule, that's a public record so in itself. So if anybody wants to see a copy of that, anybody's welcome to have a copy of that retention schedule.
And multiple categories in that schedule are permanent records that we can't get rid of.
Right.
Okay.
Yeah, and that's why I said I wasn't exactly sure what record for, I heard Historical Society word came out, and I was like, okay, what are we discussing? So, okay, thank you. Thank you.
This is a clarification. It was mentioned that records were being destroyed. So we're not talking about the schedule, we're talking about records being destroyed. And it used to be in the state statute that if there was a local historical society, they reviewed the records to see if they needed to be kept and what they wanted to be kept, not the state.
Yeah, that's not the law.
That's not the law anymore?
No, ma'am.
Okay, thank you. Just needed that clarification.
We'd be getting
Anyone else?
public documents.
Okay, moving on. Correspondence, events and meetings. Zoning Commission meeting Wednesday, May 18th, 2022 at 7 p.m. at the Safety Center. Cleanup Day, Saturday, May 21st, 2022 from 9 a.m. to 3 p.m. at Home of the Brave Park. Story time with the Symmes Library, Monday, May 23rd, 2022 from 10 a.m. until 10:30 at Mead Park. Symmes Honor Veteran, Friday, May 27th, 2022 at 7 p.m. at Home of the Brave Park. Memorial Day holiday, Monday, May 30th, all public buildings will be closed. Yoga in the Park begins Wednesday, June 1st, 2022 at Hopewell Meadow Park at 9 a.m. Hazardous household waste drop-off Saturday, June 4th, 2022 from 8 a.m. to 10 a.m. at Loveland High School. Board of Zoning Appeals Monday, June 6th, 2022 at 7 p.m. at the Safety Service Center. Regular trustee meeting Tuesday, June 7th, 2022 at 7 p.m. at the Safety Service Center. Old business, we have none. New business, I move to schedule a work session to discuss landscape medians along Montgomery Road, slides at Symmes Park, and play structure replacement at 7 Gables.
Second.
Discussion. What date works? Let's stroll through this. Can we do it towards the end of the month? Kim, did they come back with a plan yet?
No.
You haven't heard from him? Okay.
Don't you just want to...
Same night, we did that.
We could.
Do it what?
Same
The
night
same
on the
night.
19th. Just do it after our other special meeting.
That's fine.
You're going to be here.
That's fine. So I move to set it May 19th at 6:15. Can I say 6:15? Does it matter? Yeah. 6:15.
Well, you think you're going to get
For a
through
work
this other
session?
thing in 15 minutes?
Well, we can be late.
Okay.
Okay.
Second.
Roll call.
Mr. Beck.
Aye.
Ms. Lees.
Aye.
Mr. Bryant.
Aye.
I move to set a public hearing date for the tax budget of June 7th, 2022 at 7:05 p.m.
That's the first item on our next meeting.
Okay. Roll call.
Ms. Lees.
Aye.
Mr. Bryant.
Aye.
Mr. Beck.
Aye.
Okay, I want to open a discussion concerning Camp Dennison landscape request.
What is it?
We've been working on landscaping the triangle, and I know that in our notes from the administrator, she got a one bid. Thank you.
A bid or
Yeah.
or a quote?
Quote. And so I was looking for some direction. I know we also need to talk about trees too. You just want to come on up, Barb, so we can work this out. I think, this is what I think about Camp Dennison. We put all this money into our parks, other places. We really haven't done much for Camp Dennison. I think it would be a nice little pocket park. I know Phil has been talking with the engineer
Mhm.
about closing that street. So I would really like to invest some time and make it a really nice little area down there. So I'm willing to spend some money and make it nice. So that's why I just want to make sure that it doesn't fall through the cracks and we keep it on. And so I would like to invest in it.
Yeah, I have talked with Eric Beck about, and he's open to it. It's just somewhat complicated in that he has to coordinate with the state because of the state route. But, you know, he was even curious why there's two roads branching out.
Everybody asks that.
I'm sorry?
Everyone asks that.
Yeah.
Like,
yeah.
and
One would suffice. Yeah. So he's open to it. They're just going through their typical protocol of reviewing the request. I'm still baffled at why we only got one price quote
Right.
out of all the landscape companies around.
I think everyone's too afraid to give us a quote because the prices keep changing.
yeah,
Okay. So they just put a time, I mean, it'll give us some feeling though, rough order of
I
magnitude.
know, but I can't make people give us a quote. I mean,
They just put a deadline on their price.
I'm just going to say what I think. Number one, I understand and appreciate wanting to stop the split in the road, but I think it's hard to do a design or a landscaping design on an area that's undefined, that doesn't belong to us. So I'd like to see these things worked out before we even come up with a design of cost.
That's one thing I can't get the county to answer me on.
Okay.
I mean, we need their permission and they've not given us anything. They've not even responded.
Well, I'm okay with going ahead and landscaping, and then if we have to add on to it down the road. I mean, I think that little area would be nice for like picnic benches and things like that. So, but I would definitely like to see the triangle landscaped to enhance. I think I'm okay with moving forward on that.
Didn't we put a bunch of trees and things down there once before? Didn't we have permission
Well, you-
from the county to do that?
It was,
Yes.
but it was never really landscaped. It was kind of like hodgepodge.
so there was permission given, and there were 4 trees planted along.
Is that all? Okay.
There were 4 trees, and actually there were 2, I believe there were 2 other trees. Judy Havel gave me the original bid from the landscaping company. The thing that I have been experienced on trying to get prices on trees is that the trees aren't being delivered this year. I think it has to do with COVID. They weren't dug up, they weren't balled, and they aren't being shipped. So I've talked to Grant Farm about specific trees, trying to find out prices. He said we keep waiting on the trees. Talked to somebody who works for the Arboretum today also, and he said, I'm waiting on trees for different things who work for the zoo. And so I think that's maybe part of the problem with getting some of these bids on the landscaping designs.
Yes, I understand that.
Also.
But I think what's done with the road and how it's done is going to impact the plot, if you will, that needs to be landscaped.
My opinion would be very minimal that would be added to that area. It definitely makes a difference in that road being gone, but the landscape design that I received is focusing on the cannon, the signage, the flagpole. It's keeping everything along that, everything that's already there that can't be moved, the monuments. So it's focusing along that area. The only thing that might be added into it is like a flagstone path to kind of take you a little bit more to a moment within that landscaping.
Okay, if the road comes out and splits at the monument area, okay, do you have any idea which one will be given up?
No. If I may jump in.
Yeah.
So that's
The
Cougar
side
Mill,
one.
right?
Cougar Mill,
Cougar
yes.
Mill.
Yeah.
So at that point, State Route 126 is on a slight curve, and so ideally, if you're going to do that, you would want to create a right angle.
Yes.
So it
perpendicular.
might not be either of those.
Right.
So
That's
if
been our
we,
experience with other things that have got.
so if
done.
we kept that right-of-way dimension free of a tree, for example, then, and we just work around that, everything else should theoretically stay there.
And everything on the landscape design, nothing would be, if they were to make that turn a larger turn, for lack of a better word, a nicer, easier turn to the right, it really wouldn't impact any plantings whatsoever at all.
Okay.
I think both of those
I
existing
think it would
roads
help if we
would be
if we
removed.
could see what somebody's come up with for a plot layout and the cost
I think you
estimate.
have it.
We do, we approved a landscaping plan last year.
We did?
Yeah, we just can't get any bids on it, and I can't get permission from the county to actually do what we're talking about doing. It's not our property, we don't own it. What?
I must have missed that one.
Well, we have a bid, right?
We have one bid.
One bid.
That's now probably 5 months old, so it's probably no good anymore.
Yeah.
So can we call them back and see if it's,
He calls them all the time. I don't know what to tell you guys. He calls them, bothers them.
Well, but calling back to the original landscaping company
And see if
the
the bid is
design?
still-
I don't know
allowed.
who he's calling. He just tells me that he's calling his people that he deals with to get a bid, and he got one, and nobody else will give him a bid.
so why can't we go with the one bid? Even though you say it's 5 months old.
Well, we can't. We don't own the property. We need permission from the county to do anything there.
Yeah.
I thought you had that.
I
We
talked to
can-
them about the roads. I mean, I don't think they're going to tell us we can't put in plants as long as the plants don't decrease the visibility from a driver perspective.
Which they won't.
Right.
But then who's going to maintain it? Well, didn't we have them maintain, the company that put it in is going to do it for the
For
first
2 years,
Yeah.
but then who's going to maintain it after that? We only got 3 people in the park. That's all I'm going to say. We don't have all
I
this
think we
slew of
can
people to
figure
go
that
around and take
out.
care of
We
this
can
stuff.
probably
Well,
get
right
some-
now right now it's being maintained by Camp Dennison residents. I mean, and they came down and mulched. They did some mulching to clean it up, for the
Yeah.
funeral that went by that area. They wanted it to also to look nice from what I understand.
Yeah, and I think in 2 years, maybe we can figure something else. We can figure something out. I mean, we got plenty of time.
Yeah. I think we work on what we can work on, getting the county permission and find out what the road's gonna
So,
do and come up
can-
with plans and costs.
Can you see if Eric will let us go ahead and move forward with the
Yeah.
landscaping?
Kim, could
So we can
you
get that
send
done
me-
at least this year?
Can you send me a copy of that again, the landscape plan?
Yep. And
Send one to me
hopefully-
too, please.
And if, send us the
I don't know that I've
the
seen
one
it,
quote that
honestly.
you got as well.
I sent it to your email, but did you read it?
Yeah, well, might have went to the wrong email, who knows?
Well, it
Just
was
the
a long time
sketch,
ago.
yeah, the sketch and the quote, if you
Okay,
don't
all
mind.
right. So
All right.
so that's going to be our goal for next, to get everything done, so we can move forward.
And we
Okay.
need to identify a
when?
funding
For when?
source.
Okay.
Because like I said, this year I did not plan to do this project.
So
right.
the signs there's a couple of signs. One sign that I had talked to you about was the Camp Dennison, I wrote it down, sorry. The Centennial sign that needs to be maintained, is that something that can begin to be in process of being repaired?
I don't know if he's gotten quotes on that yet or not.
I know they were also checking on the cannon.
Yeah, as far as refurbishing that. Mhm.
Yeah.
Does the sign, I forget, does that need to be rebuilt? Or is it faded? Or
It's
does it just
water
need-
damaged. The seal got broken on
Right.
it and it's water damaged.
Right, that's like the one outside our
So-
administration building. Yeah.
So
Dumb
I guess,
question, but who owns it?
well, it's the same sign that's in front of the admin building.
Yeah.
Right, but who owns it? Is it a sign that we own and we
Which
installed
And-
there?
Well, and also Morgan's Raiders came and put a sign on that area also, so, you know.
Right, no, what I'm getting at, Barb, is we only have limited authority where
Sure.
we're allowed to make repairs and fix things. And if we don't own them, I think it's a question of, can we spend township monies to fix things that we don't own?
Who put
Well-
that sign there to begin with?
That's what I'm asking.
No, but, I mean, it would have had to have been the
Can I
township.
ask a clarification real quick?
Yeah.
That bicentennial sign is owned by the township.
Okay.
It is owned by the township. That piece of property is owned by the township.
No, it's not.
Yes, the
Which piece of property, Carol?
Cannon area. It was owned by a defunct called Hamilton County Association, and when the board wanted to put the trees in there,
Okay.
Bob Malloy, Wooden Lamping, went through the process of taking that property over. It does belong to the township.
Okay.
It is. And it's in the master files.
You missed something.
You missed a lot.
I did, I'm so sorry. I've just
No.
been sitting here a little bit too
Carol
long.
says that the property is taken over by Symmes Township.
I'm sorry?
If you look on the
Cannon.
Hamilton County's website, it says Hamilton County Commissioners own that property.
Okay. All we can do is
I don't know
ask.
how we can lay claim to something that it says on the website.
Unless it was never
Jeff, if
recorded.
You can look through.
Yeah, no, I'll look.
Was there a deed that was not recorded, potentially? I don't know.
Happens all the time.
Jeff, I think we did it by adverse possession. We did a notice in the paper to the defunct organization, and nobody responded, and we took it.
Okay, I mean, I can, I'll review our.
Then we
file.
shouldn't have a
Okay.
problem landscaping it, should
Do we
we?
know about when it was?
Well, that's one step
Yeah,
forward.
that helps.
Now I have to figure out the road. Okay.
Get a bulldozer with a bunch of dirt, just,
Yeah, really, just come in.
I know somebody owns a bulldozer.
Okay, so then I also wanted to talk about your trees. So you talked to ODNR and
ODNR, I guess it's a question of, so I was told that ODNR has this property, Symmes Township has this property.
Okay.
I mean, like, we're right on the borderline, and there's already a line of trees there. So we're
on the ODNR side or the Symmes Township side?
on the Symmes Township side, that run in front of my house, from Clement, Clement, the beginning of Clement, which turns into Ulrich, is it Ulrich? And it goes halfway down to Campbell, and that's where it stops. So there's just recently been 4 trees that have been taken down for the rest of the way down to Lincoln, and that's where we were trying to finish planting trees.
And those were on ODNR property?
Those were, the ones that were taken down were on ODNR because they were hazardous, they were
Okay,
huge.
that was my understanding. anyway.
So the idea would be is that we were told that we could plant more trees there, but it would have to be over on, Symmes Township line. And that was kind of the question that came up, whether we were allowed to plant there or not plant there because it was the right-of-way supposedly.
Kim?
We don't plant trees in rights of way. And just so you guys know, I pulled that Cages map and the line is right on Clement. So
Could
the
we
right-of-way-
plant trees on ODNR if they gave us permission?
Mm-hmm.
We can buy trees and she can plant them, but we can't plant them. It's not our land.
If the trees were bought, they could be planted. I have men in Camp Dennison who have the equipment to plant the trees.
Well, we would be happy to give them to you, but what I don't want to get into is this constant maintenance. Because if we plant a tree, then we're going to be obligated to maintain it, and I don't have enough people on staff to go around and maintain all these trees.
Got it.
As far as watering while they're young.
I mean, it's a maintenance
I mean,
nightmare,
we
and
can
especially
give
the
you one
place
of those
she's talking
things you just
about.
pour water in.
There's
You know
not
what I'm
enough
talking
tree lawn.
Just a bucket?
There's not enough tree lawn there to
No,
successfully.
It goes on the tree.
Like, it's not going to be a successful tree. That's why they die, because there's not enough, the tree lawn's not big enough. And plus, it's probably rock and
Well, how long
not
were
great
those-
soil.
How long were those trees there?
The trees
That
that
they
were
cut
there,
down?
oh, years and years and years. The trees that we planted have been there for 15 years.
Okay, so if we buy you trees and give them to you, that's okay?
That's okay.
Okay, we can do that then.
Okay.
Do you, is there specific trees that you want?
I've been talking to, because we actually, although, I'm not even going to bring it up. Because we.
It's been a long night.
Yeah. Yeah, I have a list of trees like Japanese, and now I shut my.
You can give the list to Bill. Okay, you're going to talk that over with Bill.
All right.
All right, we'll get him to get you the
All right.
trees.
So, I'm sorry.
How many trees?
4.
4.
Yeah. And then.
5.
I hate to be picky, but you guys need to, if you could
Well,
set a budget
you have to-
amount,
you have to
because
work-
we've already spent $1,000 on planters. So I think there needs to be some kind of budget amount instead of it just being unlimited.
Okay.
They're $150. What the price I was quoted was $150 a piece.
Okay, so less than 1,000. That would be the budget. Okay.
Yeah, and the planters, by the way, are being filled by Camp Dennison residents.
That's nice.
Or at the Civic League, actually, is who did
And
it.
you're taking care of them,
And we're taking care of them.
And are they pretty?
The flowers are all in my backyard right now. We're waiting for our
Okay.
pots to
Well,
arrive.
we hope you enjoy them.
We'll see Bill.
Okay.
Thank you, Barbara.
All right. Okay, so let's see. I have a discussion concerning speed limit signs on Snyder Road. I think Phil mentioned that at our last meeting that since, go ahead.
Yeah,
That's you.
yeah, with our recent talks about the Snyder Road property, a topic that has come up again and again and again is speeding. It's a 35-mile-an-hour posted road, but people just don't necessarily abide by that, and with the ups and downs of the hills, I think it would be very helpful to the community if we install the same type of digital speed limit signs that we put on in Camp Dennison on State Route 126.
Temporary signs that get moved?
No, permanent, just like
The ones
State
that
Route
go on the
126.
poles. Yeah.
You know what I'm talking about in Camp
Yeah,
Dennison?
I know we got some in Camp
You
Dennison.
got
I
them
didn't
coming both
realize that they
ways.
were permanent.
Yeah.
Yeah, those are permanent.
Okay.
So I guess we have to I guess we'd have to have somebody go look out and see how many we need.
It's a county road.
We-
You're
yeah,
going
it's
to
a
need
county
permission
road,
from the
and
county.
One side of
Oh,
it's
okay.
Symmes and one side of
Gee,
it's
we just
Sycamore.
need to have Eric
Is
Beck come
Sycamore
out
gonna
to
put
us
something up on the other
and just
side of the
have a
road?
meeting with us.
Well, hold on.
We'll have to do a study just like we did in 126 in Camp Dennison. They're going to want a study.
Well,
Nothing's
that's the
easy.
state.
Well,
That's
Right, but I
different.
would think
We
the
know it's
county
highway
would probably
traffic.
want the same thing.
Maybe.
We at
More
least
than
need
we
their
think it
permission.
is.
I can already tell you, Eric Beck is open to this also, because he recognizes the issue. So,
Side issue. Last night was the Hamilton County Engineers Zoom meeting.
yep.
Yeah.
Was any, I didn't attend it, but was there any material presented on number of accidents at different locations in the county?
No.
No.
They used to do that in their booklet. Okay.
So, back to your point though, yes, it would, these signs would only be on the Symmes side of Snyder, but it would behoove us to work with our neighbors in Sycamore
Okay.
and see if they would reciprocate, but I think it will send a message
What
if
are we
we,
talking to?
I don't know exactly.
What, I mean, you get that steep hill and.
Yeah, I
Right.
think
It
we
all
should
depends
have
on
Bill
sight
probably
lines.
make a recommendation on how many signs we need, right? Because
Yeah.
he would be the one. Would he be the one to do that?
It's kind of interesting. I
Yeah,
don't-
but Ken makes a good point. I mean, where would you put them?
Well,
On the.
I think we need. some
You need
guidance
line
in
of
that.
sight. Line of sight's
Traffic
going to
study.
dictate your space.
Yeah, so we'll have to have somebody go out and look at it.
But, it's kind of interesting. I never knew the speed limit was 35, because I know that we fought with ODOT, even on Montgomery Road, of the frequency of speed limit signs, and coming out southbound on Montgomery Road out of Deerfield Township at speed limit of 45, we have to go quite a distance in Symmes Township before we saw a 40-mile-an-hour sign. And we worked with ODOT for a long time to get one near the UDF, which is right after you cross out of Deerfield Township. So, I mean, frequency of signage, posted signage is one thing, in addition to where do you locate the
Well, that's all dictated by that
variable sign.
that ODOT green manual,
Yeah,
where you
I
put speed
think-
limit signs.
I think we need some help with that.
But
Well-
then keep in mind, those things are like $3,200 a piece. So
Yep.
just
Right. Yeah, we know.
be cognizant of
We
that.
don't know if we need two, if we need one, if we need, because it's so,
I see at least two,
yeah. So,
both ends of
well,
the
you're going to be
steep
busy
drop.
with Eric back.
But, I mean,
$3,200 a piece.
to make these digital signs effective, you put them in close vicinity to an actual posted sign. That way, you see your speed flashing, and you see the actual posted speed has a reference.
Well, you know what, now that you say that, I think Bill said that we would have to remove the sign that's there and put it in the sign, that's posted place. Like, we can't have two, we can only have one. So we would go, so if
Okay.
you go by the number of speed limit signs that are already on the road, that's where we would have to put them.
No, because the
Okay.
digital one it's recording your speed that you're going.
Right, but
So
then you
have the-
take that mounted speed limit and you put it on the sign as well. You put it on there with
Okay.
the same,
That
like
would
it's
solve it.
together.
Right,
Yeah.
that makes
Okay.
sense.
I see us needing some guidance and help on this, but the item itself is of interest.
Yeah.
Yep,
there's a
for
need.
sure, for sure. And if there's anything else we can do to try to make that road safer, we're open. Okay, so are we moving on?
Yeah.
Okay, I move approval of Resolution G 2022-53,
Nope.
resolution.
We tabled it.
Oh, no, I'm not, I'm reading 53.
She's reading 53.
Oh, she's reading 53, I thought she said 52.
I said no, 53, resolution authorizing the purchase of Butterfly IQ ultrasound system for Symmes Medic Unit for Butterfly IQ B-Fly Operations Incorporated in the amount not to exceed $6,730.
Second.
Discussion,
Yeah, I'd like to know what this is.
I have no idea.
ultrasound system.
Yeah, it's an ultrasound machine.
Let me read my staff report.
Be nice if we knew what they were doing with it.
Well, maybe if there's like, I don't know, hemorrhaging or something that the ultrasound can pick up. They're trying to modernize themselves, I don't know.
Just request made by the fire department. How many of these?
Just one, two.
Two? One for each
One for each
medic
medic.
unit?
Yep,
Is Levelland doing the same thing?
yes.
Okay, roll call.
Ms. Lees,
Aye.
Mr. Bryant,
I don't know. I don't know what it is.
I agree.
It's an ultrasound machine.
Yeah.
I know, but I'd like to know more about it myself.
Do we have Bruce's phone number?
The Butterfly IQ is a pocket-sized portable external ultrasound scanner. The system is used for diagnostic ultrasound imaging and assessment of adult and pediatric patients' anatomical structures for various clinical applications such as cardiac, peripheral vessels, hard-to-start IVs, pulmonary function, and obstetrics. This device is compatible with both Apple and Android mobile devices and can be used to collect valuable clinical data in the field to better enhance a patient outcome once they reach a place of definitive care.
So we're taking on more of the hospital function
Yeah.
before we get to the hospital.
Well, and my question is, how much enhancement to what they do in an ambulance or on their way to the hospital, how much does that enhance? What's done?
I would think that the way she read it, it said hard to put an IV in and so on in certain areas. You can find out.
No, it has nothing to do with putting an IV in.
It just said it.
Kim, would you read that again?
It helped, people that have bad or small veins, they
Yeah.
can assist it. I'm all for if it's gonna help a life, no problem.
Yeah, save a life.
Yeah. I don't know why
Says
we're
the system is
debating that.
used for diagnostic ultrasound imaging and assessment of adult and pediatric patients' anatomical structures for various clinical applications such as cardiac, peripheral vessels, parentheses, hard to start IVs, pulmonary function, and obstetrics.
Okay.
All right, roll call.
Mr. Bryant?
Aye.
Mr. Beck?
Aye.
Ms. Lees?
Aye. I move approval of Resolution G 2022-54, resolution authorizing expenditures from American Rescue Plan Act Fund for adopting the standard allowance for allocating funds.
Second.
Discussion. Roll call.
Mr. Beck?
Aye.
Ms. Lees?
Aye.
Mr. Bryant?
Aye.
I move approval of Resolution G 2022-55, resolution authorizing expenditures from American Rescue Plan Act funds.
Second.
Discussion?
Kim?
Yep.
The previous resolution really says we're going to do something according to a schedule, and then this one tells us we can use it.
The first resolution says that we are going to adopt the standard allowance,
Okay.
which under the Treasury guidelines says that
Okay.
we can claim up to $10,000, or I'm sorry, $10 million in losses, and we do not have to have a specific purpose for those funds. It can be used for any governmental service that we provide.
Okay. Now
Then we adopt the second resolution that says that we're also going to use the money for projects. So if you're going to use them for certain projects, you have to identify what those projects are.
Okay.
And last year, we had a whole list of things that we wanted to get done. So I listed them as vaguely as I possibly could so that it would cover us in case that we changed our mind. And basically what it is like water and sewer projects, stormwater projects. We know that we're going to use the money to build our addition on the service department building.
Okay.
What else did I put in there? 55. Oh, park. Yeah, new maintenance building, the park structures, new maintenance equipment, road repairs and maintenance, and stormwater and public infrastructure improvements.
Okay.
Okay, roll call.
Ms. Lees?
Aye.
Mr. Bryant?
Aye.
Mr. Beck?
Aye.
I approve Resolution G 2022-56, resolution authorizing the Township Administrator to enter an agreement with Stiles and Sons to repair a stormwater pipe on Tanager Drive in the amount of $49,791.
Second.
Discussion, roll call.
Mr. Bryant?
Aye.
Mr. Beck?
Aye.
Ms. Lees?
Aye. I move approval of Resolution G 2022-57, resolution authorizing the Township Administrator to enter an agreement with Choice One Engineering for engineering services for Snyder Road Sidewalk Project in the amount of $14,500.
Second.
Discussion?
This is just for the engineering.
Yeah.
Is this both north and south ends of Snyder, or just
This
one?
would be preliminary, so it wouldn't be all the engineering. This would
No,
just
not
be.
for the whole road, because the whole road would be impossible, but are we
Right.
talking about from Kemper north
Kemper
the
to
bridge?
Hamiltonian. Yep, so this would
Okay,
just be
to
looking at the
Hamiltonian.
feasibility of putting sidewalks on that side. Basically, we need to assess how much right-of-way do we have?
Okay, understand.
How wide of a sidewalk can we actually install in that location? Because depending on how much right-of-way we have is going to dictate whether it needs to be 7 feet wide because it's got to be to the back of the curb, or if it's going to be 5 feet wide if you have a 4-foot lawn.
I understand. Now, this only deals with the southern end of Snyder.
Yes.
Not from Fields Erdel to Palm Meadows.
No, the Fields Erdel to from Paul Meadows Drive to Fields Erdel, and then from Fields Erdel to Escort, that's all covered under the other Public
widening of
Works.
Fields Erdel.
Right, that's all during the
Right.
widening of
Okay.
Fields Erdel.
So my question was one of clarification. Thank you.
Okay. Roll call.
Mr. Beck?
Aye.
Ms. Lees?
Aye.
Mr. Bryant?
Aye.
I move approval of Resolution G 2022-58, resolution providing the declaration of nuisance for the property located at 11817 Inyart Road and authorizing all necessary steps for the abatement of the nuisance.
Second.
Discussion, every year. Roll call.
Ms. Lees.
Aye.
Mr. Bryant.
Aye.
Mr. Beck.
Aye.
I move to move into executive session, ORC Section 121-22, G1, to consider the compensation employment of a public employee or official, or to consider the purchase of property for public purpose, and conference with the attorney for the public body concerning disputes involving public body and are the subjects of pending or imminent court action.
Second.
Roll call.
Mr. Bryant.
Aye.
Mr. Beck.
Aye.
Ms. Lees.
Aye.